Council, if you'll just indulge me again, we're very much aware that this is being broadcast to people who might not have seen this on yesterday and who might be tuning in today. I'm not sure whether that would be a substantial number of people, but nevertheless, I'd like to welcome everybody to day 2 of this hearing. And as you all know, we will be addressing the question referred to this court by the Lieutenant Governor and Council. Is the Greenhouse Gas Pollution Pricing Act Canada unconstitutional in whole or in part? And for those who may not have watched the proceedings before a Court of Appeal previously, I want to stress the following points. We will be asking a number of questions over the course of this hearing. Please do not make any assumptions from the questions we ask or the comments we offer about what we may be thinking in the end or what we may decide. Assume nothing from the questions posed, and to that I would add comments offered. The parties and interveners have all filed factums with this court. These are written arguments which the members of this court have read in advance of this hearing. And the main purpose of oral argument is to allow the court to have a dialogue with, and I might add, a full and frank dialogue with the parties and interveners about issues or questions of interest to the court. And of course, to hear the oral submissions of primary concern to the parties and interveners. And so we're ready to continue now with day 2. And in our speaking order, we are now going to hear from Sask Energy Incorporated and Saskatchewan Power Corporation. Right.
Thank you very much, my lady. Good morning, ladies, my ladies and my lords. It's a privilege as a member of the Saskatchewan Bar to have an opportunity to appear before you today. I'm here with my colleague, Colin Willett, who's not as new to this court as I am. We don't have a condensed book for you. Our submissions were already fairly condensed. And given the 15-minute time limit, I don't intend to really pull you into any documents or cases in any great detail. Just cover the high points of our arguments.
May I just suggest, could you just speak up a bit?
Certainly.
Because I'm not sure that amplification mic is working, and Madam Clerk will also let us know if there's any issue. Thank you.
Okay, I will speak up, but thank you very much. So my clients are Saskatchewan Crown agents responsible for generating and transmitting electricity in the case of Sask Power, and in the case of Sask Energy, distributing natural gas. Our position is that the legislative jurisdiction for these statutory responsibilities is based in 92A, the power of provincial legislatures to exclusively make laws in relation to the management, development, and conservation of natural resources and electrical generation sites and facilities. I intend to address our 92A arguments. I will also talk about our 125 arguments if time permits. I noted your questions yesterday particularly about whether the national concern doctrine can override an enumerated and exclusive grant of legislative power, and I'll answer that, attempt to. I'm also going to address the lingering applicability argument that's been pointed at us. Before I go to those points, though, I wanted to make a few general comments about 92A and the business of managing electrical generation and natural resources. So we've noted in our factum that 92A was born of a period where the federal government engaged in interventionist policies in the energy sector, and that's how Justice Laforêt described it in the Ontario Hydro case. And so 92A was part of that constitutional compromise entered into with Canada in 1982 to help preserve Confederation, which had been strained by those policies. This was that honorable bargain by which the federal crown recognized that the provinces should be entrusted with the exclusive competence to legislate over the management of natural resources and electrical generation. And that was an important bargain for the provinces to push for, because the energy needs and capabilities of every province is indeed different, and there is nothing more local, more of a local concern than the heat that warms our houses and the power that keeps the lights on. And as noted in our materials, my province does not have any more hydro power opportunities. Saskatchewan is a cold place. I mean, I love it, but I just came from there. It's a cold place for much of the year. We have a modestly sized population spread out over a region that is bigger than, has a mass bigger than California. And what keeps the homes warm and lit in Ottawa does not work in Meadow Lake. But in Saskatchewan, the legislature not only expects my clients to keep residents warm, my clients are equally responsible, tasked with energy efficiency, implementing cleaner technologies, and reducing emissions. That is part and parcel of managing electrical generation and natural gas distribution. And in my submission, it fits neatly within 92A. Now, I'd like to address the question that Justice Wakeling posed yesterday. What does the law mean to those subject to it? And how does it affect the behaviors of those subject to it? And the effects on these Crown utilities, and thereby the residents of Saskatchewan, are significant. They're set out in our material, summarized in our factum and in our affidavits. SaskPower needs to run its coal-fueled units below maximum capacity to keep the charges down, which is actually less efficient and affects the lifespan of the machines. And since it's less efficient, it actually means in the long run burning more coal, not less. The excess charges under Part 2 for SaskPower are estimated at somewhere between $500 to $600 million by December 2022, and it's not certain that all of this can be passed on to the consumer. Sask Energy will pay a similarly significant amount under Part 1. Now, you would have read in our material that SaskPower has a plan to reduce greenhouse gas emissions and greatly increase renewable electricity by 2030. It's anticipated, however, that the federal law will delay plans to invest in more wind and solar power because whatever capital is available for those investments, in the short term, it's going to be needed to help expand existing natural gas facilities that are not going to involve the level of charges that the coal fuel plants will. Also, you will have noted that there was plans near Moose Jaw to build a state-of-the-art natural gas facility that was more efficient by 30 to 40% than the existing natural gas facilities. But because it was recently announced that the new natural gas facilities are subject to a descending emissions threshold under the output-based pricing system, which is not applicable to the expansion of existing facilities, those plans are in jeopardy too. And of course, it's anticipated.
So just clarify that. You're saying for new ones, the charges are higher than they would be for expanding existing facilities?
That's what that's in our affidavit material as a result of a recent announcement. It's also anticipated that we may have to start importing power and jobs will be lost. So that's what this law means to the people who are subject to it. It's certainly affecting the behaviors of my clients as they manage the province's electrical generation and natural resources and strive to meet their plans for energy efficiency and emissions reduction. So when you consider the purpose and effect of this law, my submission is that the law is indeed about the regulation of natural resources. But even if you
repeat that, the law is about?
Indeed about the regulation of natural resources. But even if you go with one of the less pith and substance characterizations that have been given to you, we submit you still run headlong into 92A. The preamble of the legislation, the regulations, they're all pointed right at the natural resource sectors and right at the energy sectors, those who consume the natural resources. The legislation is very much about managing how electricity is generated and how natural gas is used. The rate of production, the technologies used, even, unfortunately, how many employees we might be able to staff in that area. It's all impacted. It's not just a single distinctive issue. These are multifarious issues that are impacted by this legislation. Now, you asked us to address whether the national concern doctrine can override an exclusive grant of legislative competence. Now, respectfully, there's no logical way to explain how POG can override 92A when POG is expressly limited, as you pointed out, to matters not coming within the subjects exclusively assigned to the legislatures. Now, my friends have pointed to Crown Zellerbach and Ontario Hydro as cases where this overriding occurred, but Crown Zellerbach didn't involve a legislative grant as specific and pointed as 92A. That you may well have grants of power, broadly worded ones like property and civil rights, where there may be a temptation to surgically remove a single and distinctive area, move it into the national realm because it's become nationally important. But when you have a specific and distinctive grant already in 92A, you can't do that. If you actually let Canada manage natural resources and electrical generation, then the grant of 92A is simply lost.
Council, is there any class of law described in 91 and 92 that approaches the detail in 92A?
Not that I'm aware of. Not that I'm aware of. And then Ontario Hydro pointed out that there was a discussion of 92A and atomic energy, and the question there was whether or not the regulation of a nuclear power plant's labor relations remained with the province, because electrical generation is involved. Laforêt concluded that it didn't remain with the province. But in doing so, he was noting that the declaratory power had already been exercised by the federal government over atomic energy. And when he went into the POG power, he accepted Canada's argument, which you'll see at page 379 of that case, where he noted the whole purpose of the federal regulation of nuclear electrical generating plants would be frustrated if Parliament could not govern the standards and conditions of employment for those plants. So in other words, and he also talked about national defense and nuclear power and all those sorts of things. In other words, the national concern doctrine there was not being used to simply override an exclusive grant. It was being used there to facilitate the exercise of the declaratory power.
And in that regard, the constitutional amendment under 92A3 makes it clear that the declaratory power remained intact, the federal declaratory power. And if one reads the entire history of the negotiations leading up to Section 92A, you will see that, in fact, at one point the provinces of Alberta and Saskatchewan had hoped to have that overridden. In actual fact, it wasn't overridden, and that is the conclusion that was reached if you read the history, that they didn't succeed on that, which is why you see in the Constitution 92A3.
Yeah.
So the declaratory power remains intact. No one disputes that.
That's right.
And what I hear you saying is what is really at issue here is reducing greenhouse gases on the one hand and the economic development of natural resources on the other.
Yes.
And that runs headlong into the right, the constitutional right of the provinces, the exclusive right to manage natural resources.
I agree entirely with the way you framed it. And I might try to frame it another way using a hypothetical. What if, for instance, the federal government decided that it was a matter of national concern to impose a blend of pricing and regulatory policies on the natural resource and energy sectors aimed at promoting the Canadianization of energy resources and the encouragement of conservation of energy? Would that national concern doctrine allow that intervention? It's not that far-fetched a question, because I took that hypothetical out of the Supreme Court's description of the National Energy Program. In the export tax case, export and natural gas tax case. And 92A was designed, it was intended as a response to that, to prevent that from happening again. And yet here we are today with a federal law seeking to impose pricing regulations on natural resources and electrical generation. Now, the good news is it's been 35 years, and 92A, I submit, has never really needed to be tested. Its time has come. Now, as much as the Supreme Court of Canada has in these past cases caused us all a little bit of confusion and maybe some consternation about overriding exclusive enumerated grants, if you look at more recent cases, such as the securities case, as my friend referenced yesterday, it's a different story. And we refer to that case on page 4 of our factum under the heading Respect for Exclusivity and the Written Constitution. And what the court said in that case is, while flexibility and cooperation are important to federalism, they cannot override or modify the separation of powers. The secession reference affirmed federalism as an underlying constitutional principle that demands respect for the constitutional division of powers and the maintenance of a constitutional balance between the federal and provincial powers.
Council, may I ask you one question about the reference at the Saskatchewan Court of Appeal?
Yes.
And in particular, were you representing your client at that time?
My firm was, but I wasn't available to attend.
I just wanted to know, because obviously we're not familiar with what happened there. Was this issue of Section 92A actually argued before the court?
It was, and I know I've got less than 5 minutes probably, and this goes to that applicability argument. There seemed to be this conclusion reached by the majority of our Court of Appeal anyways, that Sask Power and Sask Energy were making an applicability argument. I can see how you might reach that conclusion with 125, because that's pointed directly at immunity, right? But we weren't. We were saying that 92A, and all these arguments were made, 92A meant that Canada was legislating in an area of exclusive provincial jurisdiction. But they interpreted it as, so we will be commenting on that as the matter goes to the Supreme Court of Canada, but these arguments were made.
So what you're saying is they interpreted it really as an argument about the taxation power and Section 125 and the application of that, and not the constitutionality of the legislation.
Yeah, I think that's fair. It seems that they did not really approach the 92A issue. And I also don't think 92A figured as much in the arguments of the reference appellant at the time, necessarily. But here you've heard it raised by Alberta. 92A has been raised, and so we think our arguments are not just about applicability. So I do have the 125 argument there. Ultimately, we're saying if it's not a regulation, it's a tax. And for 125, that means you cannot tax the property of the province. And I won't spend much time on it, but you can look at the export natural gas case. And what the majority said there is that 125 is a recognition of the constitutional value that the Dominion cannot take for itself the property of the provinces. You can't take away that property. And it was noted that the provision was important for the survival of the provinces in Canadian federalism.
And as I recall, maybe that was the case, or perhaps it was an earlier one, that the Supreme Court of Canada said the power to tax is the power to destroy.
Yeah. I think that might have been that case. Ultimately, I noted on Friday, the Supreme Court came down with a 125 case. I don't think the facts are particularly relevant, except it did involve a Crown agent. And the court said there that export natural gas tax case provided for a substantive, broad protection under 125. It shouldn't be viewed narrowly. So subject to any questions you have, those are our submissions, and I very much thank you for the opportunity.
Thank you. Should have asked, did the panel have any questions of Sask Powers? Thank you. And thank you. Now we're going to hear, is it Mr. Halser? Yes. Mr. Halser, on behalf of the Canadian Taxpayers Federation, one of the interveners in this matter that's supporting Alberta's position. Thank you.
Thank you, Ladyship. And thank you, Justices, for allowing us to be part of this case as an intervener. The Canadian Taxpayers Federation is a federally incorporated, not-for-profit citizens group dedicated to advocating for lower taxes, less waste, and more accountable government. The CTF adopts and supports the positions that you heard yesterday from the Attorneys General of Alberta, Ontario, and Saskatchewan. And federalism is important, and it is important in this case. But that's not the issue on which we seek to participate in this case as interveners. Our interest in this case is taxation. and whether or not the carbon tax imposed in Part 1 of the Greenhouse Gas and Pollution Pricing Act is constitutional. As Mr. Justice Laforêt wrote in the GST reference, and your ladyship just alluded to it, the power to tax involves the power to destroy. For this reason, all governments, federal or provincial, must not be permitted to impose taxes without strict adherence to the Constitution. Now, the average Albertan heating their home or filling up at the pump probably will not care whether a carbon tax is imposed by one government or another. But the CTF says, and we believe they do care, that there is accountability and that the government which imposes a tax has the jurisdiction to do so. Part of this is the principles of federalism that you heard about already. But it's also important that tax imposed by the federal government meets the test of Section 53 of the Constitution. And what most concerns the Canadian Taxpayers Federation in a broad sense is the explosion of administrative charges by federal and provincial governments in recent decades, and the tendency of governments to avoid the inconvenience of strict compliance with Section 53 by characterizing taxes as administrative charges. And in our respectful submission, this is happening with the carbon tax, a tax which may well be authorized by Parliament, but which is in fact imposed through regulations which apply to some provinces and not others, in some years and not in others, based on the determination of appointed officials rather than elected parliamentarians. The predominant effect of the federal carbon tax will be revenue generation. There is no doubt, in a fair review of all the materials, there is no doubt going to be some long-term effect on consumption by the increased cost of energy, although nobody can actually say what that effect will be. The Attorney General's expert, Dr. Rivers, says that while there may be a very small short-term effect from the rise in energy costs, over the long term, the carbon tax will depress demand for carbon. So while the effect of the tax on carbon consumption may be gradual, its effect on taxpayers will be immediate. How low-income families, rural families, those who live in more severe climates in Canada will be disproportionately affected immediately. And they will not receive the benefit of this tax in any particular sense. The predominant character, and certainly the predominant effect of the carbon tax, will be that people pay more tax for energy that they consume, and the government will generate revenue. It is true that the Act also deals with how the government may spend that revenue, but I'll get to that in a minute. The test, as we've heard already, for whether a levy is a tax or not was articulated by Sir Lyman Duff in Lawson versus Interior Tree Fruit Growers in 1931. And the four criteria are that it has to be enforceable by law, which the carbon tax is. It has to be authorized by Parliament, which in the broad sense this tax is. It has to be imposed by a public body, and tellingly, this tax is imposed by the Minister of National Revenue, not the Minister of Environment or any environmental agency. And the tax has to be intended for a public purpose, which we would agree that this is. These criteria are clearly met. Of course, that's not the end of the analysis, as your ladyships and your lordships know. Something may meet the characteristics of a tax, but still be a regulatory charge, and there's been a number of cases at the Supreme Court that have dealt with that. The principal cases I'm going to discuss in my brief time here are West Bank First Nation versus BC Hydro and 620 Connaught Holdings. In West Bank, which incidentally was approvingly cited last Thursday by the Supreme Court of Canada's decision in BC Investment Management Corporation, the court sets out two factors to consider whether a tax may also be a regulatory scheme. The first one is whether a regulatory scheme exists, and If so, whether the levy is suitably connected to that regulatory scheme. And for a regulatory scheme to exist, Westbank says that the court should consider the following 4 factors. And it's not you have to meet all these 4 factors, but there are factors for the court to look at. One is there a complete, complex, and detailed code of regulation? Secondly, is there a regulatory purpose which seeks to affect somebody's behavior? Thirdly, is there the presence of actual or properly estimated costs of the regulation? And fourthly, is there a relationship between the person being regulated and the regulation, where the person being regulated either benefits from or causes the need for the regulation?
Counsel,
Yes.
as I read both Lawson and Westbank, before you get into the particular criteria that you're going through very fairly, I read both of them as saying there's an overriding criteria that has to be met before the sub-criteria. And the overriding criteria with respect to whether a matter is a tax is whether or not it raises revenue for general purposes. And if that is a correct reading of Lawson and Westbank, can you tell me where in this particular act you can show that it raises revenue for general purposes?
Well, Your Lordship, this act obviously raises revenue from consumers, be they individuals or businesses. That money accrues to the Dominion. I will concede that the Act does require the Dominion to return that money to the provinces, but there aren't any specifics in the legislation about how that money is to be returned. Through regulation, through policy, it may be returned to consumers. That's been an announcement of the Government of Canada. Not in any sense connected to how the consumers who actually pay the tax, and we don't actually know the details of it. It may be returned it may be given to the provincial treasury. Some of it is going to be given to schools and hospitals. But none of that is set out in the Act. All of that is set out in regulations. It's essentially still a discretionary spending power of the government. And in my respectful submission, there's not enough specificity to say that that's not for general purposes. The Dominion maintains significant discretion over how that money is going to be spent. And, if at the moment, for, I would argue, political reasons, they are emphasizing that money is going to be returned to consumers in some fashion. But there's nothing in the legislation that requires that. It may well be that in a couple of years it'll change and there'll be some federal purpose in the province that money will go to.
Well,
that's all done by regulation.
With respect to Part 1, if you are a province that has come to an accord with the federal government, the province collects 100%. So the federal government gets nothing. And if you're a province that the backstop applies to, you've got a 90-10 split, with 90% being returned to the consumers and 10% to hospitals, schools, et cetera, et cetera. How does that, when that scheme is in play, let's just deal with Part 1 firstly, how does that then accord with the requirement, the overarching requirement for a tax that it must raise revenue for a general purpose? And that is that there will be a net left in the hands of the federal government.
Well, Your Lordship, in respect of a province where it is not imposed, for example, British Columbia, there is no revenue raised and there is no tax because nothing's imposed. That's part of the discretionary nature of this scheme. So in my respectful submission, we're only talking about provinces where the federal government decides to impose the tax based on whatever criteria it determines to apply on that day. British Columbia is exempt from it now, so there is no tax, there's no collection of revenue to return. It could be that in a couple of years, for whatever reason, the federal government decides that it doesn't like British Columbia's scheme. British Columbia isn't charging enough on its carbon tax, and then it will be imposed. And when you say the money is going to be returned to consumers, that again is discretionary. We don't know. We know that that's the intention of the government today through regulation, but we don't know that that will always be the case. It may be that it's returned to provincial governments or to other entities in the province, and we don't, and even how it's returned to consumers is a matter of discretion. Whether everyone in the province gets an equal check, or whether it'll be an income tested thing, or whether there'll be some scheme set up to actually encourage people to buy electric cars or something, we don't know. All those things are potentially possible under this regulation. So in my respectful submission, that's far broader than what the Supreme Court of Canada would have considered in Lawson and Westbank as being a revenue neutral thing. There is a collection of revenue for the federal government, and the federal government is going to decide how that revenue gets spent within, I will agree, certain parameters.
But what I hear you saying is that in your view, this statutory regime that currently exists is so broad that the federal government could tomorrow decide that the 10% remission back to the province is now 30-40%. In other words, it could reduce the number down to you're not getting all the money back, you're only getting part returned to the province.
Well, I do think the legislation requires them to spend the money in the province in some fashion, but how that's spent other than could change from year to year.
So what you're saying then is that there is no assurance that it's going to be returned to the consumers generally, that it could go back to the province, or it could be used for specific purposes within the province that are unrelated to returning of any funds to individuals. And indeed, if it was decided, it could also be used to return it only to certain individuals through tax credits, maybe on the basis that this is a regressive tax, but to accomplish, let's say, a redistribution of wealth, which essentially is the progressive taxation system we have in Canada.
You're exactly right, Your Ladyship. I see that my time is about to expire, but I'm going to commend my factum to you. I do want to point out one thing in my friend Ms. Tulls Langdon's reply argument, is she points out the Johnny Walker test as refuting the idea that if the taxes aren't spent, or I'll try to be quick. In Johnny Walker, as I'm sure you're aware, there was an excise duty, and the province of British Columbia challenged whether it should have to pay that excise duty on liquor being imported into British Columbia, because that was a federal taxation of a provincial undertaking. And the Supreme Court of Canada determined that this was a tax. It met all the criteria of a tax, but it also was a regulatory scheme because it was predominantly aimed at regulating the impact of alcohol in the province. My friend raises this case to refute the suggestion from Westbank and from 620 Connaught that the collection of this tax, if it's for general revenue, can't be a regulatory charge. And she says, well, here's the general revenue, but it was found to be a regulatory charge. And as I said, this is one of the 4 criteria. I think what's important, if you read the Johnny Walker case carefully, is that the court found it could be either, and it had to go into a discussion of what is the predominant characteristic of this. And they found that its predominant characteristic really was for a regulatory purpose, and that's why it was a charge. In my factum, and I'd also urge you to read the minority decision of the Saskatchewan Court of Appeal. In my respectful submission, when you go through the carbon tax, it is primarily for the collection of revenue. It may well have an indirect effect on eventually on the consumption of energy products, of carbon, but that is an indirect effect. Nobody can tell you how much that's going to be or when it's going to be. Let me just close by saying Section 53, there are many fine words spoken in many Supreme Court of Canada cases about Section 53. It comes out of the English Bill of Rights. It enshrines the principle of no taxation without representation. Many courts have quoted the quote that the power to tax is the power to destroy. The reason why this keeps on coming up is because taxation power is so awesome that it must be heavily scrutinized. And when your lordships and your ladyships are considering this, if there's any ambiguity, and it could be a regulatory charge or a tax, we would urge you, as a Canadian Taxpayers Federation, to find that if it is ambiguous, it must be a tax. The default position is that it must have the scrutiny of Parliament. And the trend of governments to avoid that scrutiny must be stopped, and we would urge you to stop it in your decision, and those are my submissions.
Thank you so much. Does the panel have any questions? And thank you very much, Mr. Halsell. And thank you. And now we're going to hear from the International Emissions Trading Association. And is it Ms. DeMarco?
Thank you, my lady, my lords. In my brief introduction, I would like to cover 3 areas in support of the validity of the Act under the trade and commerce power, on the clear understanding that if its operation in fact, i.e. supported by fact, sterilizes the provincial 92A powers, it must be read down.
I'm sorry, I didn't catch that last point. You're saying that the power, on the clear basis that
if it in fact unnecessarily encroaches upon the provincial powers in Section 92A and or sterilizes those powers, it must be read down. I'm confessing to being the source of the Saskatchewan Court of Appeal decision that led to applicability of 92A as opposed to using 92A as a validity argument.
Well, I think we have a lot to discuss with you because this association, the International Emissions Trading Association, when, at least speaking for myself, when I read your factum, I'm not quite sure why you're not on that side of the table, because you're obviously supporting the federal government's legislation, and yet you suggest you're somehow neutral here, but you're actually asking for the constitutionality to be upheld. So you do slide into, at some point in the factum, a reference to, but if something comes up in the future that might go a little further, maybe it will unduly trench on the powers, and it's like, okay, well, what would that be? So maybe you can enlighten us, because speaking only for myself, I'm having some difficulty understanding why it wouldn't simply be we're supporting Canada, because everything you've written reads that way.
It appears as though no one thinks we're their friend in this proceeding, and we fall not neatly within either camp in that we don't support going forward under national concern. Rather, we see this act, the true essence and nature of the act, as falling within trade and commerce. And then secondly, the clear distinction is that if, in fact, if there's evidence before this or a future court that it encroaches upon provincial natural resources powers under 92A, it is no different than any other act.
Perhaps I could follow up on that then. If your position is that 9127 of the Trade and Commerce Power fill in the necessary legislative authority for this, is it your position then further that there's no purpose in a national concern doctrine at all?
I wouldn't be as bold as to question the Supreme Court's jurisprudence on this. I will go as far to say that it's fairly clumsy. It's a fairly blunt tool for an act that can be much better precisely characterized under the Trade and Commerce Power. And so, to that end...
Well, I'd just like to follow up on that too, because I'm not sure what you're in essence saying. Are you saying that this can only be supported under the Trade and Commerce Power, and that you do not agree that it can be supported under the National Concern Doctrine? Well, let's come at it the second way. We've heard your position that it can be supported under the Trade and Commerce Power, so let's just get right to the real point. Are you suggesting, or do you agree, that it can be supported under the National Concern aspect of POG, yes or no?
I would say that extremely narrowly characterized. With a number of factual contingencies, it is possible that it could be supported under national concern, but this court does not need to go there. It is best supported under the trade and commerce power.
No, that doesn't answer the question. That really, in my view, just begs the issue, because you're adding, as my Lord Watson said, a number of qualification, not necessarily perhaps with this, if you twist this and turn that. We have a record in front of us. You have the same record. You have the same legislation. You're here on behalf of an organization. We're asking a simple question. Do you agree with with Canada's position that this existing regime can be supported under the national concern doctrine? Yes or no? It is a yes or no.
We would say that, and unfortunately I can't give you a clear yes or no. Under the most limited circumstances, yes. Under the best ideal circumstances, under the record now before you, better under the trade and commerce power.
I think that takes us then to your characterization of the Act. Do I read your factum correctly in paragraph 31 in terms of what you say the characterization should be? And here's what I read. And it's a bit of a summary as to what you've said in paragraphs 29, 30 above. To establish national carbon pricing and trading regime that allows for a variety of provincial approaches and potentially interprovincial compliance trading in order to facilitate nationwide GHG reductions consistent with Canada's Paris Agreement commitments. Is that fair?
Yes, specifically we indicate that the Act should be characterized, and we are business organizations, including the oil and gas sector, including the mining sector, including manufacturing sector, indicate that the characterization of the Act, A, should be precise, and we've got the Desgagnés case in our materials indicating that that precision must be incurred, as GHG emissions pricing and trading regime that establishes minimum national pricing stringency standards in order to reduce Canada's greenhouse gas emissions in accordance with the Paris Agreement. And that precise characterization flows from an examination not just of the preamble, as my friends would have you look at, but of an examination of the entire Act in its context, the letter of that law, as we would urge you to examine.
With the addition of the concept of trading, particularly under Part 2, trading of credits, that seems to me to be fairly consistent with the majority opinion in Saskatchewan. Is that your intention?
That's right, and the concurrent decision of Justice Hoy in Ontario.
Absolutely. Thanks for that addition.
Yes.
Okay, I think I
To
understand
that
where you're
end,
coming
I
from.
wonder, I passed up a few sets of materials. I hope that you have them. This is supported.
You said that you represent industry, and as I understand, you're a nonprofit organization with over 150, you say, Albertan, Canadian, and international business and business industry members that span the mining, oil and gas, electricity, utilities, etc. And obviously you're not representing all the organizations in Alberta, all oil and gas industry representatives. You represent some.
That's fair.
Okay,
That's
thank
fair.
you. Secondly, then, if we can then zero in, you say you support this under the trade and commerce power. You're not prepared to commit to saying that on the national concern side, it's a yes or no. So your position on that is, I prefer not to weigh in on it. Is that a fair comment?
That's fair.
Okay. And then third, you say at paragraph 54 of your factum, to the extent that the implementation of the Act in Alberta or any other province has the effect of what you call sterilizing the core elements of an expressly enumerated area of exclusive provincial jurisdiction, including those set out in Section 92A, and in particular, Section 92A1C of the Constitution, the act should be interpreted in a manner that reflects the express balance of powers in the Constitution and rendered inapplicable to such class of subject. Now, I have to be honest and say I have a lot of difficulty with that because I'm not quite sure what you're getting at. On the division of powers analysis, the purpose is to decide whether the act in its present form is constitutional, and that is a yes or no. And we can't say we don't want to get involved. So we have to actually make a decision on that. So when you say, to the extent the implementation of the Act in Alberta or any other province has the effect of sterilizing the core elements, it should be interpreted in a manner that reflects the express balance of powers and rendered inapplicable to such class of subject. What are you saying? Are you suggesting that there is some aspect of this in its current form which is now unconstitutional?
No, we support fully the constitutional validity of the Act, but we leave open the questions for future courts, whether or not the Act, when it is operating, has an evidentiary factual impact that would render it inapplicable to natural resources in the province. So we fully support the constitutional validity.
Well, that's an interesting theory because usually when courts make decisions that an act is constitutional, is it open to a court to then come back a couple of years later on application by any party and to say, even though it's been implemented, the act has been implemented in accordance with its terms, we decide now on reflection that it's unconstitutional?
If there was an issue around the courts, the operation of the Act, of course, an entity could challenge it. Let me take you very specifically to the first item.
Do you have any authority for that proposition? Any legal authority cases?
Just the regular operation of laws and constitutional challenges of laws going forward. And very specifically, in relation to the validity, there is no evidence before this court right now that indicates clearly, economically, that there will be a negative economic impact on Canada's natural resources. In
So
fact,
are you saying that,
there's the
for
opposite
example,
evidence.
the interjurisdictional immunity test is geared to sort of a sliding scale, and that how bad it gets then pulls in that test, or what are you saying?
I'm saying it's subject to evidence. And in fact, the evidence is contrary in this.
So constitutional law would depend on facts, on a particular case.
It's the fact.
And the public would have to rely on what the Constitution means in the future, and to predict that maybe somewhere along the line somebody would say, oh, the facts are, oh, you've gone too far now. Now it's gone. I mean, all these industries that you represent are going to rely on a statement like that?
In effect, it relies upon the first step of the test that Justice Wakeling spoke to yesterday. And that is really in relation to looking at how we characterize, there must be that essential analysis of what the Act does from the factual perspective of those that are regulated. And that was the first step of the letter of test.
That's relevant to determining the matter.
That's right.
I get that, but that's something not what you're talking about.
That's at the front end. At the front end, you look at the effects.
That's right.
You're assessing it now. You don't go and look at the effects 2 years from now and say, you know, actually that worked out a little worse than the Trade Emissions Trading Association thought. So now that we've established that it's been a kind of a really bad intrusion and things are not going very well in terms of the economic development of natural resources, let's say in Alberta or Saskatchewan, we'll bring a challenge and say, you know, they appeared in front of the Court of Appeal and said, there really isn't any evidence that this is going to be so bad, so we want you to uphold it on the trade and commerce power, and don't worry about the intrusion on Section 92A, because we'll wait and see how things work out. And then in 2 or 3 years, you can come back. If you find that it's really bad intrusion, that takes it into a different category. Your friends have said the issue isn't whether the intrusion is how bad it is. It's based on whether or not it is an impermissible intrusion.
That's right. And I would say, if I haven't been precise in that, it's that first step on the facts, on the effect that I'm going to. And if I can turn you, please, to the first page of the materials that we've submitted, we have there evidence from Mr. Savage's cross-examination. And when asked, without the levy, is the economy expected to grow by 2.27% annually? He answers yes. And right, so it would seem like the difference is 0.05% difference, yes. And that's what that shows. But the oil and gas sector actually grows with the levy, more than without the levy, yes.
Well, what's that, I mean, now you really are into what are the effects from an economic point of view, and your argument appears to be that people should not be unduly concerned because they're, in looking at this whole issue, you're inviting us as a court to conclude that this is like de minimis, that there's not really going to be a significant impact on the development of natural resources, and therefore, while at first blush, Section 92A is engaged, don't worry because it's not going to be that significant an impact, and look at the evidence here that says you'll still have some growth. I mean, in essence, that sounds like it is your argument, is it?
It is not. The argument is that, in effect, there is no negative impact.
Okay, well then yours is that there's no economic impact. Is that it?
There is no negative impact on the regulated sectors. And looking at the purpose and effect, that first step of the Letterman test, one cannot conclude that the law is, for those who are regulated by it, the law is, for those who are subject to its purpose and effect, invalid. Going through
Perhaps I could go to your main point, though. Of course, you're invoking 91.2, the trade and commerce power.
That's right.
And you're suggesting that this approach, this statute, meets the 5 steps in General Motors? Is that what you're saying?
We are, and I see that my time is coming very quickly to an end.
Don't worry, because we've asked you a lot of questions, so we're going to allow you to continue on, because it's an
I
interesting
apologize for being
submission.
less than polite here. I'm fighting a little virus, so if you don't mind, I will just stand and sit as...
Please feel free to be seated if that's more comfortable for
Thank you so much. I apologize for the informality of that. Very specifically, with the classification that we've discussed with Justice Feehan, I take you to tab 6 and paragraph 103 of our record. And at that paragraph, I will rely on our factum, paragraphs 40 to 43. And it sets out the argument regarding the 3 indicia of a trade matter. And we would rather rely on the factum to merely submit that the law is part of a general regulatory scheme. The scheme is under the oversight of a regulatory agency. And the law is concerned with trade and competitiveness as a whole, rather than with a particular industry. And in that regard, I think it's extremely important for this court to look at what the law does and what the law does not do. And while that's part of the characterization, it's extremely important to understand that the law does not regulate all greenhouse gas emissions from all sectors. It does not regulate greenhouse gases, Madam Justice, from the agricultural sector, including cattle. It does not prohibit, Mr. Justice Wakeling, or allow for the prohibition of the use of your gas lawnmower or your gas stove. And it does not impose directly or indirectly limits on oil and gas exploration. In summary, the Act does not regulate on an exclusive basis all aspects of greenhouse gas emissions. It is focused rather on systemic and competitiveness risks. And in that regard, yesterday there were some errors on the record before the court as to how the Act does that. So if I can ask you to refer to the materials we've handed up, we've given you the specific references as to precisely how the Act does that and what the reference standards are. And so that is in the record before the court. It's an extract from the appeal record and evidence of the Attorney General of Canada, Volume 3, and in the affidavit of John Moffat, Tab 1, Exhibit SS. And in terms of the rightful confusion around what are the standards, how are they set, I would note that they're laid out very clearly there, and a number of Alberta industries are at the 95% level, number one. Number two, a number of Alberta industries are at the 90% level. And that level was not set at the random will of Cabinet. It was the subject of a three-phase test that looked at the trade and competitiveness exposure of all of those sectors. And that process is also set out in the same affidavit. And I'll commend you very specifically to page R923 of that.
Can I just clarify one point, because we've asked you a lot of questions about where your organization is on certain aspects. But you did say earlier that the evidence is important, and I believe your words were there was no economic impact to this levy. Okay, no economic impact, and I've added the words of this levy, but that's what you're obviously speaking of, I assume. So I think what I hear you saying, if I'm correct, is that your position is that the evidence before us does not reveal that there would be any economic impact of this levy. Is that your position?
If I wasn't precise in that regard, it was in relation to oil and gas.
Well, okay, fine, in respect of oil and gas. So in your position is there's no evidence on the record before us that there would be any economic impact on the oil and gas industry of this levy. Is that your position?
I would argue, and I would set out specifically your modeling, the evidence before you, states the oil and gas sector actually grows more with the levy than without the levy.
That's a different issue. It could be growing more and more yet if it didn't have it. That's perhaps the question of interpretation of the evidence. I just want to ask the question again. And again, to me, this is actually a yes or no question. Is it your position that the evidence before us reveals that there is no economic impact on the oil and gas industry of this levy? Yes or no?
My submission is there is evidence of a positive economic
Okay. So let me then rephrase it again so that I'm very clear on what you're arguing. It is the position of your organization that based on the record before us, that there is a positive economic impact on the oil and gas sector from this levy.
That is, in fact, Mr. Savage's, Alberta's economic modeling evidence, yes.
No, it's not a case of whether or not it's Mr. Savage's or anyone else's. I just want to clarify again whether this is your position, that there is a positive impact on the oil and gas sector from the imposition of this levy, yes or no? Is that your position?
Supported by this evidence.
Well, then, is the answer, yeah, it is yes, thank you.
One other thing, though, is if I understood your focus, you've drawn us to Mr. Moffat's stuff and the OBPS, and there's a list of different specific types of industries there, right? And you've said, in fact, if I understood what you said before, this statute does not regulate greenhouse gases from all sectors. It doesn't go across boundaries. It actually is aimed at those industries listed there, right?
Yes.
Okay. Then how does it meet the third criterion, General Motors, of concerned with trade as a whole rather than with a particular industry?
It does cover the breadth of industrial emitting sectors. It does
How do you know
not
that?
cover agriculture.
Well, agriculture is an emitter, isn't it?
It is. It is.
Right. So this is targeting at specific industries, not trade as a whole. It's not like the GST. It's targeting specific industries for specific effects, and you're saying that meets General Motors.
I would say that it targets the 19 industry sectors that are outlined. So in general, it does target trade as a whole and doesn't. The contrary test, single out.
If it hit three big ones, that would be good enough for your analysis to meet General Motors.
19 big ones is good enough.
I appreciate that. Your frankness is to your credit. Thank you.
Okay.
And so I see that I am definitely out of time. The last two criteria, I will have to rely upon my factum for. They are very closely analogous to the provincial inability test, and I would say that in that regard, it again meets the last two criteria of the provincial inability.
I realize that you're not upholding this or seeking to uphold it under the national concern doctrine, but I would be interested in understanding how the notion of division of powers should be informed by whether something is good for the province or bad for the province. Who makes those choices, the province or the federal government? Because you say, in essence, this is going to have a positive impact. Looking at that, you should put on the scale the fact that this will actually be beneficial to the oil and gas producing provinces. I'm saying that because you zeroed in on the oil and gas sector. So does that actually go into the mix in deciding on who has the jurisdiction, whether something will be good for province?
I would say that's an element of the classic division of powers test as to whether or not a matter is in relation to one dominant characteristic and does not unduly sterilize or encroach upon a matter, in this case, within provincial jurisdiction. So the scale of impact is relevant.
Well, but the scale of impact's a different issue than whether it's good for you or bad for you. Do I understand you to say then that if it were bad for the provinces, then that would mean that it doesn't fall within the federal power? It's only because in this case it happens to be, in your view, beneficial.
The test is effectively, does it sterilize or unnecessarily encroach upon a head of federal power? And so
come back to my question, which is, why does the fact that you say it's positive enter into the analysis when the decision is arguably that of the provinces as to whether or not to do something? You're saying, well, this would be positive for you, and so you should be, in essence, embracing this because this will be beneficial to you. So why object to any federal intrusion into your power?
What I'm saying is, on the factual analysis of that first element of the characterization of the law, the facts matter. And the extent to which this specific law will factually encroach is extremely relevant. Will factually have a negative impact is extremely important as to whether or not the dominant characteristic, the test very clearly set out.
But you're saying it's a positive impact today based on what this is. So there's a levy of, let's say, 30 tons, $30 a ton, $40 a ton, $50 a ton. Now, you were here yesterday. You received a copy of the mandate letter that's been given to the minister in terms of what's to be done. Is it going to be a positive benefit to the development of the oil and gas sector when the levy hits $300 a ton? And what about $500 a ton? What about $1,000 a ton? Is that still going to be a positive benefit to the industry?
Let me put this in this context, and in this regard, the specific price that we understand and that has been analyzed is $50 a ton. And in that regard, that may in fact be protective from a trade and competitiveness perspective. Specifically, we've heard internationally the EU and other countries imposing a border carbon adjustment on goods coming into their jurisdiction. And so from that regard, to the extent that Canadian goods and products that come from emitting industries have the benefit of a carbon compliance regime, it may in fact be very protective of Canadian industry. So yes, that is my perspective.
So
Council, let me understand in the simplest terms your position. Here's what I understand you're telling us. the first thing we have to do is we have to characterize the matter. We have to do that before we move on to jurisdictional questions. There are two components to characterization of the matter, purpose and effect. I asked you the purpose question 20 minutes ago. You gave me the answer from paragraph 57, I believe it was, of your factum. And what you're now going on to tell us is that you also need to address the effect piece, and that's what you're doing. And it's that simple.
It's that simple.
Thank you.
Well, I'd like to understand when you're addressing the effects piece, you're saying, because I want to be very clear, because the evidence is important, you say the evidence before us has been modeled on a $50 per ton amount. Is that correct?
That's my understanding in this regard. In this specific example, the scenario was $30 a ton, the actual number at this point in time.
Well, it's $50 a ton. I'm asking a question about, there's also evidence before us that could go to $200 to $300 a ton. And I am asking whether or not your theory is, your position is, that as the price increases, that's as beneficial or more beneficial or less beneficial to the oil and gas sector.
I would urge you to disregard the evidence that says $200 to $300 a ton is before you right now.
Well, if actually, though, based on your rationale from before, if the Europeans and everybody else decided to push it to 300, 250 would be looking pretty good.
It's really the associated outcome that's extremely important in this regard.
My point is that you are here suggesting that there is a positive impact, that's your position, to the oil and gas sector from this levy. And I am simply wanting to know whether on your theory, from your position perspective, given the fact that there's a variable rate that can be charged, and the evidence here is that it could go as high as $200 to $300 a ton. I believe I can stand to be corrected on that, but I believe that that's what this record indicates. If that is so, is it your position that as the price goes up, it becomes more beneficial, less beneficial, or remains the same? I just want to know what the theory is.
I do, unfortunately, Madam Justice, have to go at the preposition of that question because it is not my position, it is the evidence before the court. It is the record before the court.
You're saying that your record that you're relying on is premised on a $50 per ton charge for carbon dioxide emissions. I'm simply asking you because you obviously have a theory on how that's beneficial in terms of what is said here, whether you can elaborate on whether that would hold true if the price went up or down, or are you saying you don't know what the economic impact would be then?
I am certainly not an economist. I have not done that analysis, and I would be loath to speculate before this honorable court.
So I take it from what you've said that none of the people who gave affidavit evidence here gave any indication of what the impact would be were it to go above $50 a ton.
It's not my understanding, but I will leave that for my friend from Canada to clarify.
Okay, well, I do understand what you're saying, which is that you are relying faithfully on the actual evidence before us, and that's a credit to you that you're zeroing in on that so precisely, because that is very helpful to us. So thank you so much for your submissions. And is there anyone other? Yes.
Can you give me the names of some of the Alberta corporations that are members of the organization that you represent?
Happy to. On the, I can actually undertake to get you a complete list of AIDA members, and I will
just
do
give me a handful. Just
Believe
so I have
Al.
a good idea.
Chevron, Suncor, ATCO, Capital Power, and I don't want to leave anybody out, but I will certainly give you a full.
It just gives me an idea.
And there was one other factual clarification I did need to do to the record, Mr. Justice Wakeling. You yesterday referred to the California Energy Commission banning gas stoves. They have not. So we've got the record before you as to precisely what happened in relation to 6 local ordinances.
Are they thinking about it?
No, it's in relation to local ordinances as to whether or not they were going to overrule them. And it was a local control matter. And I've given you a quick summary of that, just again to protect the veracity of the record.
And you alluded to the fact that somehow the issue of agriculture had come up, and I think you said, Chief Justice, agriculture is not included, and we're certainly well aware of that. But a question, could it be?
Very unlikely in terms of how the scheme is set out. In particular, the agriculture sector is looked upon to produce the offsets to facilitate the compliance, trading, and flexibility in the Act.
The issue isn't whether you think it's potentially on or off the list. The question was, could it be under this existing legislative framework?
Theoretically, it may be possible under the offsets portion, the compliance trading portion of the Act.
Thank you so much. We'll take the morning adjournment now and reconvene in 15 minutes. Thank you. Well, thank you very much, and we're now ready to proceed with Canada's submission.
Good morning, Chief Justices. My colleague, Ms. Moore, and I will be making oral submissions on behalf of the Attorney General of Canada today. To assist the court, we have prepared an outline of our oral argument, which should be tucked in the first page of Canada's condensed book. And we have also prepared a condensed book, which, while thick, is quite a condensation of the volume of materials that is before this court. I'd like to note that in the index of Canada's condensed book, that we have listed the authorities under headings that relate to the issues. Each case is listed when it appears the first time it becomes relevant, but simply because it's listed only under, say, the characterization heading, does not mean that it's not otherwise relevant to other issues that follow. I've also asked the clerk to ensure that you have volume 3 of Alberta's Book of Authorities handy, and I believe that should be there and available for you. It is the volume of the Book of Authorities that includes the Ontario and Saskatchewan Court of Appeal decisions. The reference question before this court asks whether the Greenhouse Gas Pollution Pricing Act is constitutional. Canada says that it is. Canada's position on the reference is that this court should advise the Lieutenant Governor of Alberta that Parliament validly enacted the Act under Section 91 of the Constitution for the peace, order, and good government of Canada to address a matter of national concern. The context of this case is one of the greatest existential issue of our time. It is undisputed that climate change is an urgent threat to humanity. Greenhouse gas emissions are not contained within geographic boundaries. The rapidly increasing accumulation of greenhouse gas emissions in the atmosphere is causing global warming, which is causing global climate change and the associated national and international risks to health and well-being. Greenhouse gas emissions are an interprovincial and international pollutant with known, long-lasting, and deleterious effects. The Greenhouse Gas Pollution Pricing Act is a key part of how Parliament is addressing the national aspects of this problem. Parliament's ability to establish minimum national standards integral to reducing nationwide greenhouse gas emissions as part of the global effort to slow climate change is a matter of national concern. Canada's outline provides an overview of the points that my colleague and I plan to address today. The outline identifies 3 distinct issues, which of course break down into many sub-issues. I will be addressing the first issue, Parliament's peace, order, and good government jurisdiction, for the majority of Canada's time. My colleague, Ms. Moore, will then address the issues relating to characterization of the charge under the Act and for the remainder of Canada's time.
Councillor, can you help me with how this impacts people on the ground? Let me give you a couple of examples, and that will assist me understand what's happening here. Suppose you have A, who lives 30 miles from downtown Edmonton. He has a business, and his annual income is $1 million a year. He drives a Ford F-350, and he pays on account of the, is it $4.43 cents a liter for the, if there wasn't a non-qualifying jurisdiction, so that the backstop rule applies. And he spends $1,000 a year on that extra charge. Then you've got B, she's a law professor, and she lives close to the university, drives a Toyota Tercel and a bike. And her contribution is $25 a year. At the end of the year, somebody is going to give back in a jurisdiction some sum to people who pay these charges. The person who's got $1 million a year income and drives a Ford F-350, am I right in thinking that person's not going to back? The person who rides your bike, the 5 minutes it takes to go from her condominium to the university, is going to get something.
They're both going to get money returned under the climate action incentive. The individual who rides their bike lives in a rural, urban area.
Yep.
And the climate action incentive, there is evidence at tab, just give me a moment. Tab 24 of Canada's Book of Authorities that explains how the climate action incentive payments work and will work in Alberta. So it actually has the price breakdown. And for the individual under the $30 per ton, it speaks about the first individual will be able to claim $444 in climate action incentive. The individual, and more if it's a family household. And the individual who is living in the rural area will get a 10% increase in the amount of the climate action incentive to recognize the fact that that person lives in a rural area. So they will each get back money in the climate action incentive to compensate for the impacts. Dr. Rivers in Exhibit C of his report actually has a report that explains to this court how rebating money to offset the impact of the climate of the carbon pricing through the climate action incentive does not eliminate the price signal of the carbon charge. The carbon charge still, because there's that charge that makes you think every time, it's now a clear, visible charge. Regulations, to be clear, have a charge, and the cost of those regulations is embedded in the price that people pay for goods and services. The carbon charge is visible, so it makes people think, oh, maybe when I buy a new vehicle, I won't buy an F-350. Maybe I'll buy an F-150. Maybe I'll switch to something that's even much more efficient. There are changes that individuals can make and may be compelled to at least think about and make the decision that suits them because the charge is there and because it is visible.
So if I understand you correctly, both of them as taxpayers are going to get something back because of this.
Yes.
So the incentive to change your behavior then is just the fact that you're paying a lot at the pump when you go. Now, would the Ford F-3...
It's the visibility of the,
Yep.
of the charge, though.
Yeah, I hear you. Because for some who like driving a Ford F-350, it probably doesn't matter what you pay. They're going to drive it no matter what, unless it gets to be an exorbitant number. But there's no incentive short of not paying as much at the pump by driving a more fuel-efficient vehicle. You're not getting a different sum back. You're just not getting, okay.
You're not getting a different sum back, but the evidence that is before this court, particularly through Dr. Rivers, if we're talking about efficacy, is that this absolutely has an effect of reducing greenhouse gases.
Okay, and we'll suppose it's $440, just to pull a number out of the air. It comes back as a credit somehow. That would be to the Ford F-350 driver and the Toyota Tercel driver. Okay.
And then so the individual who is living a life that does not produce nearly as much carbon through efficient vehicles, through alternative means of commuting, they'll actually benefit.
Right, so because they're not paying anywhere near $440, they're paying $25. And the guy who's driving the Ford F-350 is going to say, Professor so-and-so is doing really well by this, and then you think, maybe they ask themselves, should I be thinking about doing something like this?
Yes. I would really like to try to spend some time on characterization of the Act. I know this panel is going to have a lot of questions, and of course, I welcome questions, but I also know that the Act is very complex. It certainly took me a while to understand its operation, and in characterizing the Act, I'm going to spend some time explaining how the Act operates and correct some of the confusion that seemed to be present in some of the questions yesterday. My submissions are going to follow the two-stage division of powers analysis approach that applies in every case: characterization and then classification.
In other words, you're treating it as if it's a pith and substance analysis.
There is a pith and substance analysis, and if you look at Crown-Zellerbach and at anti-inflation reference, both cases involve the pith and substance analysis.
Right. There was a bit of a debate yesterday about whether it's a different sui generis system or whatever,
No,
but you're saying
it is not. It is the division of powers analysis, which Ontario agrees, and we agree with Ontario on that,
Right.
that the standard division of powers analysis applies.
Right.
And so characterization begins, and it is the Act that is, and the characterization process, the pith and substance analysis of the Act, is the starting place before you move to classification. Under the classification analysis, I will first address the evidence that shows, well, I will submit that the evidence both shows that there is a new matter, and if it is not a new matter, that there is certainly a constitutionally significant transformation. Second, I will speak to how the matter is distinct and distinctly national, and this is the matter that we come to as a result of the pith and substance analysis, and that it is qualitatively different from the province's jurisdiction to address greenhouse gas emissions under provincial heads of powers. At that stage, I will, Chief Justice, yesterday you asked for an understanding of the evolution of the provincial inability test. I will cover that evolution when I discuss the second stage of the Crown-Zellerbach test. Third, I will speak to how recognizing the matter coming within Parliament's POG jurisdiction is reconcilable with the balance of federalism. And when doing that, I will address the idea that exclusivity under POG is somehow different than exclusivity as the concept is used in all of the constitutional law divisions of powers, which we say it is not. It's the same. Turning to characterization, the Supreme Court's jurisprudence is unequivocal that the first step in any division of powers analysis is inquiry into the essential character of the Act. The Supreme Court's decision in the firearms reference, which is at tab 31 of Canada's Book of Authorities, describes this. Paragraph 15 is the starting place, which describes the two-step division of powers of analysis, and it certainly contradicts Alberta's suggestion that a pith and substance analysis is not important in order to address the validity of the Act. The starting place is always the Act. Paragraph 16 describes the task of characterizing the law. It's really, what is its essential character? What is it about? What does it do? And the law's purpose, its purpose and its effect. And the law's purpose is can be determined by extrinsic and intrinsic evidence. The extrinsic evidence is the evidence leading to the enactment of the legislation and the debates when the legislation was enacted. And of course, the intrinsic evidence is the Act itself. And here the extrinsic evidence is particularly important because it ends up being referenced in the preamble of the Act. So it's brought into the intrinsic evidence being the Act itself. Because this is a case where a big part of the extrinsic evidence is the international, includes the international treaties, I refer you to tab 33, which is an extract from Hogg's textbook. And this is about the relevance of the existence of a treaty. The top of the page, it says, the section I believe is highlighted in the condensed book, moreover, the existence of a treaty will often be relevant to the characterization of implementing legislation and will tend to support the federal parliament's power to enact the legislation. It then cites Crown Zellerbach, and it does talk about the difference between implementing legislation and legislation that just refers to the international agreements. But in the end, it says, however, and this is what Crown Zellerbach did, however, the court described the treaty, and in holding that the legislation related to a matter of national concern within the peace, order, and good government power, the court invoked, among other things, the international character and implications of the legislation. We say that is why the treaties, which are part of the extrinsic evidence here, matter. And as a final point, just before I turn to the actual characterization process with respect to principles, we know that the Supreme Court just released a few weeks ago its decision in Degagné Transport. And in Degagné Transport, it spoke about the characterization process at paragraph 35 of that decision. And it made the point that a matter must always be characterized with precision. And it referenced a number of cases. Although this was the Degagné Transport was about shipping and navigation, to support that point, it said, see in the context of the pith and substance analysis, and it referenced a number of its decisions and some academic articles, particularly Professor Abel, who said vague and general characterizations are unhelpful in that they can be superficially assigned to various heads of power. Again, the question is, what is the act about? With these principles in mind, characterizing the act, I'm first going to highlight the international and national factual context preceding Parliament's enactment of the legislation. As I said, this extrinsic evidence is particularly relevant because it's brought in through the preamble. We say, considering the totality of the evidence, the Act's purpose and effect is to establish minimum national standards.
Just before you leave Wardsilla, though, that's the way I remember it. In the Transport Gagné case, I call it Wardsilla because it just seems to be more, gets you more. Sounds like a monster movie or something. Is one thing, is it fair to say about that case, though, that it does signal a bit of a return to black letter view, in that it did not allow non-statutory maritime law to permeate into the definition of navigation and shipping, or am I mistaken?
No, that's not correct, Justice Watson. In fact, the majority of six in that decision said that maritime law is part, and it is integral to navigation and shipping. It is part of the federal power of navigation and shipping. And
not all of it, though.
They said, but that, because it's not legislative, paramountcy does not apply.
Right.
And therefore, the legislation applies. It basically had a double aspect. It could have fallen either way. If the contractees had said under maritime law, it would have been decided under maritime law. The problem was the contractees didn't say which law applied.
Right.
But
like, I think, well, I won't dwell on this because it's an interesting point, but it does seem to me that once the Supreme Court of Canada says paramountcy doesn't apply to it, then it's not a constitutional principle. You know, it's not something that has a constitutional weight to it, you might say. But we can get to, I mean, I don't want to get distracted off on that. I take your point, though. I understand what you're saying. Is you're saying, no, it does not do that. It does not, it's not a return back to black letter kind of a notion.
no, in fact, the court, the majority of that court put a lot of emphasis on facilitating overlapping powers, not concurrent jurisdiction, but coordinate operation of federal and provincial laws.
Right.
Turning to the key evidence, the rapidly increasing accumulation of carbon dioxide and other greenhouse gases in the atmosphere, the grave risks posed by climate change causing greenhouse gas emissions, and the urgent need to reduce Canada's nationwide greenhouse gas emissions to do our part in the global effort to achieve the significant emissions reductions that are necessary to stave off significantly worsening consequences from climate change. These are all fundamental to understanding Parliament's purpose and to understanding the interprovincial, indeed international dimensions of this problem. Mr. John Moffat's affidavit and Dr. Blaine's expert report provide the bulk of this evidence. And I'm going to take you through Mr. Moffat's evidence in some detail today. I ask that you open Mr. Moffat's affidavit, which is at tab 7. And turn to paragraph 6, beginning at paragraph 6. So Mr. Moffat is one of the 5 affiants through which Canada provided evidence to this court. Mr. Moffat is the Associate Deputy Minister with Environment and Climate Change Canada and was directly responsible throughout the whole policy development process for the development of, in the Pan-Canadian Framework, the Working Group on Carbon Pricing Mechanisms, and in the legislative process. So he speaks from direct knowledge and direct experience, and Alberta did not cross-examine Mr. Moffat. Paragraphs 6 to 34 of Mr. Moffat's affidavit provide this court with a comprehensive picture of the accumulation of greenhouse gases in the atmosphere and the resulting global climate change, its global and national impacts, and the urgent need to rapidly reduce greenhouse gas emissions. Today, I will highlight a few of those paragraphs and exhibits. Beginning at paragraph 7, we know there is no dispute that the combustion of fossil fuels emits greenhouse gases into the atmosphere, and that this is enabling global warming. There's a clear scientific understanding of the properties of how carbon dioxide functions in the atmosphere. There is a direct correlation between increasing accumulation of carbon dioxide in the atmosphere and increasing global temperatures that fuel climate change. The atmospheric concentrations of greenhouse, and this is now in paragraph 8, the atmospheric concentrations of CO2 are fairly uniform around the globe and are higher than they have been at any time in the past million years or more. We have the NASA graph that's reproduced there right in Mr. Moffat's affidavit that shows how rapidly concentrations have been rising since 1950, and also how far outside it is the normal range of variability over the past 400,000 years. You see at paragraph 10, Mr. Moffat refers to the World Meteorological Association, which publishes an annual statement on the state of the global climate. And I have included at tab 8 an extract which was Exhibit A to Mr. Moffat's affidavit. I'm not going to read this to you. I do certainly commend you to reading this page in particular to understand how the reconstruction of past historic CO2 concentrations has shown that the last time the concentrations of CO2 were this high in the atmosphere, the Earth's equilibrium climate, because we're not there yet, the climate is still changing, it's catching up to the concentration of greenhouse gases in the atmosphere. The last time they were this high, the Earth's equilibrium climate was 2 to 3 degrees warmer than today. Now that may not sound like a huge amount, but the evidence before this court on the impacts of the difference, there is significant evidence before the court on the impacts of the difference between 1.5 degrees and 2 degrees. And we're talking a significant, the equilibrium climate the last time they were this high was much more than that.
Perhaps I could ask you to pinpoint something about this, because we are familiar with the material that you've referred to. It was put before us. And that is, you're in the course of discussing the pith and substance of this particular legislation.
Yes.
And that involves purpose and effects, and I guess you're in the area of talking about effects at this point. I put to you the suggestion, though, that the concept of effects here is not factual. It's ramifications. In other words, that the legal effects of legislation is what constitutional law should be concerned with. Now, maybe others think otherwise. There may be a lot of cases you may even be able to cite where they've looked at facts, like, for example, there's such things in Zellerbach and so on. But let me just finish my point, and you can respond. I'm suggesting to you that in order for us to have a constitutional system that is predictable and is understandable by the general public. It doesn't turn on whether or not science has moved in one way or another. And by the way, I'm not disputing your science, incidentally. You've obviously provided a very impressive array of material here. What I'm suggesting to you, though, is in the course of doing the examination of the topic that you're talking about, you have to focus on whether or not the ramifications of this law, not just its aims and its statement of intent, which is part of it, the effects in that sense. What industries does it hit? What parts of society are touched by this, positively or negatively? You follow what I'm saying?
I do.
And you'll probably disagree with that, but I'm suggesting to you that's what effects means. It doesn't mean these numbers. It means the effects in a legal sense.
Yes, and I am referring to this evidence for the purposes of the constitutional test in a legal sense to speak about, one, the purpose of the legislation. What is the problem the legislation is designed to address? And it's not just this legislation.
Well, actually, maybe I can, this is very interesting to me. That's why, and by the way, I'm not trying to challenge you on this. I'm actually trying to test this reasoning. You already have the preamble.
Yes.
The preamble of the enactment is, it seems to me, about as much evidence as Canada would require to explain itself. Why would Canada need to file affidavits to convince the public when it has a preamble that sets out all the circumstances on which it makes its decision, in effect? Is there any need to do that? I mean, why would Canada feel vulnerable? There's their preamble. That's what they got.
Right, there's the preamble. This evidence elucidates the preamble, explains the dimensions of the problem.
Yeah, but did they need to?
Well, this court needs to understand.
We understand what you're saying.
No, but this court needs to understand because in the securities reference, the Supreme Court said that the Crown must provide evidence to the court to demonstrate a constitutionally significant transformation. It's at paragraph 90, I believe, of the securities reference. No, I don't have the right paragraph off my head, but it is certainly in the securities reference. And the securities reference case, the Supreme Court of Canada said that the onus is on the government to demonstrate to the court a constitutionally significant transformation through evidence. The evidence does matter. The evidence here demonstrates the dimensions of the problem, that there has been a constitutionally significant transformation. It's no longer wood smoke coming or coal smoke coming out of the fireplace causing local pollution. We're now in a situation where the dimensions of the problem are national and are global. They have transformed because of our now understanding of what the global dimension impacts of greenhouse gas emissions are that was not understood in 1967. And I can tell you it's paragraph 115 of the securities reference.
Sorry, 115?
115.
And you're doing that in the same line as Professor Hogwood in relation to international documents.
Yes.
In a sense, you're reaching out beyond the boundaries of the country or whatever, beyond the boundaries of what the preamble might say in the legislation. A lot of acts never had preambles, so I can understand why they had to come up with evidence external to the legislation. But if the legislation itself sets out compactly what its considerations are, you're saying, I guess your point is that the preamble isn't necessarily enough. Sometimes the government might have to do more.
Right. Well, I'm saying the preamble says, whereas recent anthropogenic emissions of greenhouse gases are at the highest level in history and present an unprecedented risk to the environment, including its biological diversity, to health, human health and safety, and economic prosperity. And then 3, whereas impacts of climate change are already impacting Canadians, in particular Indigenous peoples of Canada, low-income citizens, and northern coastal and remote communities.
Right.
That's in the preamble. But just because Parliament puts it in the preamble may not necessarily make it so. So what we have brought to this court is the evidentiary record that demonstrates that what the court said in the preamble, that the intrinsic evidence of the Act is in fact based on evidence, that Parliament had a rational basis for saying all these things in the preamble.
You realize, of course, that, I take your point, actually, there's an interesting subsidiary premise to that. Once you say that, what you're saying is that Parliament's preambles are only suggestions. They may not be good enough.
Well, the Supreme Court has said that.
Mm-hmm. Yeah.
The Supreme Court has said that.
In what?
In securities reference.
Right. Okay.
I think your point is very simply, look, courts may not necessarily rely on the wording of the legislation, and
Right.
Canada has provided an evidentiary foundation which compellingly demonstrates the rationale for what is set forth there.
Yes, the rationale as well as the dimensions of the problem, that they have been transformed from local matters. They are no longer matters within the province. It's beyond provincial capacity to deal with the problem. Indeed, it's actually beyond Canada's capacity to deal with the problem. There isn't an international government that can apply. That's the United Nations, and they do the best that they can. But within Canada, the government that can do as much as it can at the national level is Parliament. But only for the national aspects. Provinces still retain a lot of powers themselves, and I will definitely cover that, but I would like to stay a little bit on characterization for a bit longer. You definitely have the point and the evidence. I do just want to highlight, again, the most recent evidence from the Intergovernmental Panel on Climate Change, which Mr. Moffat describes in paragraph 14 of his affidavit. It was established in 1988 by the United Nations Environmental Program and the World Meteorological Association to provide the world with a clear scientific view on the current state of knowledge in climate change and its potential environmental and socioeconomic impacts. The IPCC is the leading world body for reliably and credibly assessing the scientific evidence, the impacts of climate change, and the impacts of and future risks of climate change. The IPCC issued a report about a year ago, a little bit over a year ago, October 2018. It was a special report on 1.5 degrees, and it was focusing on the risks of climate change that could be avoided if globally we manage to hold the increase in temperature 1.5 degrees. And we're already at 1 degree increase over the baseline that they're using. If we manage globally to hold the increase to 1.5 as opposed to 2 degrees, we will avoid some even more significantly worsening impacts of climate change. And that is summarized in paragraph 17 of Mr. Moffat's affidavit. And some important points specific to Canada: the likelihood of an Arctic Ocean free of sea ice in summer would be once per century with global warming of 1.5, compared to at least once per decade of 2 degrees Celsius. Limiting global warming to 1.5 degrees Celsius compared to 2 degrees could prevent the thawing of up to 2.5 million square kilometers of permafrost, which provide services such as solid foundations for housing and winter roads and habitats for numerous species. Winter roads are significant in Alberta. Arctic areas, including northern Canada, are among the regions facing disproportionately higher risks from global warming. The disproportionate impact in Canada's north will have a disproportionate impact on Indigenous people living in Canada's north. The IPCC's, an extract of their summary for policy makers is at tab 9. And if you turn to page 256, you'll see, first of all, at A2, the IPCC explains that warming from anthropogenic emissions from the pre-industrial period to the present will persist for centuries to millennia. In other words, at the current atmospheric concentrations, warming that we have now will exist for centuries, long-lasting, and will continue to cause further long-term changes in climate systems, such as sea level rise, the associated impacts. But these current emissions alone, so the current the IPC is forecasting that the current atmospheric concentrations will not push the globe beyond 1.5. It will go to 1.5, it won't go beyond 1.5, is their modeling and prediction. However, in order to prevent passing 1.5, they explain that at 2.2 that we need to reaching and sustaining net zero anthropogenic CO2 emissions and declining, this is a very scientific name for other greenhouse gas emissions, would halt global warming on a multi-decile timescale. We're talking, because it's the climate, 10 years, it takes years for the effects to be felt. And the graph on the next page there at R258 shows how quickly emissions need to fall, global emissions need to fall in order to limit global warming to 1.5 degrees. And you'll see in the small graph at B, it shows emissions falling from 2020 to reach net zero at 2050, or it gives a more ambitious objective of by 2040. And you'll see that if that is accomplished, then the middle graph where it shows the temperature overreaching 1.5 but then coming back down to 1.5, if we can achieve that globally, shows how quickly emissions must fall. At the national level, climate change is having particularly significant impacts in Canada. Mr. Moffat describes these impacts at paragraphs 24 to 34 of his affidavit. A lot of what Mr. Moffat describes to this court is based on Canada's 7th National Communication on Climate Change to the United Nations. It's part of Canada's reporting obligations to the United Nations. And it also references a more recent Environment Canada publication, Canada's Changing Climate. I have included at tab 10 is the discussion of the impacts on in Canada of climate change that was published prior to the enactment of the Act. And we see at page R399 to R400 is a summary of the health and well-being impacts. Climate change affects the health and well-being of Canadians in many ways, both directly and indirectly. More frequent and severe extreme weather events increase the risk of physical injury, illness, and death. Heat waves, and this is moving on to the next paragraph, heat waves can cause heat-related illness and death, as well as exacerbate existing conditions such as respiratory and cardiovascular disease. It also mentions worsening allergies and asthma. It mentions smoke from wildland fires, which are increasing as a result of climate change. Alberta has very real effects, felt those real effects with the Fort McMurray fire in 2016. It talks about increasing contamination of drinking and recreational waters. It speaks about the increased prevalence and spread of disease that is foodborne, waterborne, or zoonotic-borne insects. These are the impacts in Canada. The global impacts have led to international agreements. The global concern and impacts have led to international agreements. And again, we speak about these because they demonstrate the dimensions of the problem. We're not relying on the international agreements as a source of constitutional authority. However, as noted, Professor, Mr. Moffat in his affidavit outlines the international commitments to combat climate change at paragraphs 35 through 53 of his affidavit. That evidence is before the court. One of the things I note as he goes through that is that in 1992, when the United Nations Framework Convention on Climate Change was first entered into, the international community was expressing concern about climate change, expressing concern that anthropogenic emissions would increase and impact negatively climate. By 2015, the language in the Paris Agreement had evolved to recognizing that climate change represents an urgent and potentially irreversible threat to human societies and the planet. This is an existential crisis that we are facing. All of this evidence, in turn, underscores the urgent need for Canada to reduce its nationwide greenhouse gas emissions, to do our part in the global effort. If you juxtapose Canada's international emissions reductions targets and Canada's international emissions history, it demonstrates or helps demonstrate the national dimensions of the problem. It shows that historically Canada has not met its reduction targets. And to make this comparison, I ask that Canada turn to paragraph 22 of Dr. Blaine's affidavit, which is at tab 13 of the compendium. So Dr. Blaine's affidavit as a whole, and it's not all reproduced here, but as a whole, she explains how measuring and quantifying GHG emissions is a well-developed science, which is a point that I return to later in my submissions when speaking about the single, distinct, and indivisible nature of the matter. But for now, if you keep Dr. Blaine's affidavit open to paragraph 22, I won't have you turn back to Mr. Moffat's affidavit, but I will tell you that paragraph 40 of Mr. Moffat's affidavit, he sets out Canada's first commitment under the UNFCCC in 1992, which was to return emissions to 1990 levels. And you see from Dr. Blaine's affidavit that 1990 levels were 602 Canada's emissions were 602 megatons of carbon dioxide equivalent. And in 2017, which is the most recent data, they were 716 megatons of CO2. Clearly.
So from you said from 1992?
From 1990.
1990, 602 megatons?
Yes, and the first international objective was to return emissions. In 1992, Canada signed, came into effect in 94. Canada signed an agreement to say it would return emissions to 1990 levels. Clearly, that's not happened.
Yeah. And now, just to put this in perspective, and I realize there's a lot of information here, but then you say 15, was it by 2000 and the 700 and some megatons is what, by what year, 15 years later?
No, in 2017.
2017.
It was 700. So the most recent data on Canada's greenhouse gas emissions is that in 2017, the greenhouse gas emissions have been calculated to 716 megatons.
And that's the first line in your graph.
And that is the first line.
22.
Yes. So across the first row is Canada's total greenhouse gas emissions, and the dates are at the year is immediately above that row.
So that's from 1990, it went from 620 megatons. 2017, it's up to 768.
No, sorry. 1990, it's
Yes.
602.
602, yeah.
2017, it's 716.
16?
16.
Okay.
That's in paragraph 22, table ES4, first line.
Yes, and that if you read Dr. Blaine's affidavit in full, she explains where it comes from. It comes from the Canada's National Inventory Report, which has to be presented to the UN each year by April 15th. She explains the whole process of quantifying GHG emissions. It's a very complicated science. It's all in there for this court's.
So that's almost 3 decades we're talking about.
Yes.
In that 3-decade period, before the legislation in question, what legislation did the federal government do to deal with the areas that it could control? What did it do about emissions from railways, from anything of federal undertakings that were within its power to control emissions? Did it have a carbon tax on any of those, a carbon levy, a carbon charge of any kind?
It did not. This act imposes the first national carbon levy, but the other things that the federal government has done are described in Mr. Moffat's affidavit.
Not what it's done recently. I'm talking about that gap period of almost 30 years and whether or not the federal government during that time took any action to control the activities that it has undisputed control over constitutionally, including in particular levying a carbon tax. And I'm asking that because other provinces have led evidence that they actually were taking steps prior to 2017.
So, yes, Alberta for sure implemented a carbon price on industrial emissions as of 2008. The federal government did not. They, when the Kyoto Protocol, when Canada was a signatory to the Kyoto Protocol, there was a draft provision to implement a national cap and trade system, and that actually generated quite a bit of academic writing around the time about Canada's ability to do that under the POG power or under trade and commerce power. Government changed, that didn't happen. But Canada did implement, using its criminal law power, some command and control regulations under the Canadian Environmental Protection Act. And there are certainly new actions that are described in Mr. Moffat's affidavit at paragraphs 174 through to 187. But Mr. Moffat also describes actions that were taken historically under the SEPA 1999 regulations, particularly in the in the transportation sector and in relation to reducing carbon dioxide emissions from coal-fired electricity generation. This was Parliament using its criminal law power.
But I take it there was nothing to do with pricing carbon before this for federally regulated industries?
No, there was not.
Sorry, can you give us the paragraph numbers again? I apologize for the Canadian efforts under their criminal law power.
Paragraphs 174 through to 187 discuss complementary measures. Some of them are historic, some of them are newly planned measures, and they all largely rely on Canada's criminal law power, including regulations under SEPA requiring the phase-out of coal-fired electricity generation. There is no doubt that the federal government can validly exercise its power to affect provincial matters that are under provincial jurisdiction, including electricity generation. Returning to paragraph 22 of Dr.
Sorry, can I just get you to go back and say that once more? You're saying that is it under the criminal law power? You're saying that Canada can do this?
Yes, that is what's been done.
Okay.
And actually, when I speak about the issue of backstop, I will actually return to particularly how the coal-fired electricity generation phase-out works, because there's evidence before the court about how that system actually works. So, but yeah.
But provinces are still mining coal and exporting it off of Canada's shores.
Yes.
I'm sorry then, can we understand better how that works together if you say that under SEPA, the federal legislation,
Environmental Protection Act.
yes, the Canadian Environmental Protection Act, you said that they took steps to reduce the coal use federally. I take it then that there's no steps that have been taken to prohibit the export of coal from Canada to other countries where they can use it and contribute to greenhouse gas emissions.
This is correct.
So it has not been done.
Canada has not prohibited the mining or export of coal.
All right.
Now, there
Well, then
are
what did
international-
it do under the Canada Environmental Protection Act? What specifically was done then? You said that was done in the context of a prohibition under the criminal law power. So is it the case that there's a prohibition that you cannot mine coal here for use domestically, but you can?
No, it's not a prohibition on mining.
What is
It's a it's a phase out. You can't do it immediately.
Yes.
It's a phase out using criminal law power of coal-fired electricity generation.
Okay.
So it's provinces that are still using coal-fired electricity generation, which includes the province of Alberta, the province of Saskatchewan, I believe Newfoundland. I'm not entirely 100% sure. This is where Ontario reaps the benefit of having already done it. They're not affected by these regulations. And 175 specifically talks about the phase out of coal-fired electricity reduction regulations that were passed initially in 2012, and they've been amended since then. Turning back briefly to paragraph 22 of Dr. Blaine's affidavit.
Can you
I
hold
won't-
up the tab again to go
Yes.
back?
With tab 13.
Thank you.
And I won't juxtapose Canada's emissions relative to Canada's targets for each of the Kyoto and Copenhagen targets.
If I'm sorry, I just want to take you back to coal, because I know coal is particularly problematic in terms of greenhouse gas emissions, and I think we all recognize that the problem is not just national but international, and that in fact can be seen the magnitude of the problem by reason of the fact that the recent collective of governments in Spain did not reach any accord on certain environmental initiatives that were being sought. So I just want to be clear that this has these regulations, the reduction of carbon dioxide emissions from coal-fired generation and electricity regulations deal with what is happening with the use of coal in Canada, and that the regulations, the recent amendments, have the effect of phasing out units producing electricity with coal by 2030.
Yes.
And that it's needed to provide certainty, it says, around investments that can have a long life, and the regulations to phase out coal-fired electricity generation should prevent new investments in new coal-fired electricity, regardless of other market considerations. And I just want to clarify the point about the fact that coal is still being mined and exported from Canada, and there are no prohibitions on mining and exporting of coal to other countries in the world. Is that so?
That is so.
Okay.
Not at this time. And I can't say, I don't know that there's any such thing planned. But I do know that internationally, all of the other countries are also signatories to the Paris Agreement, subject to the U.S. pulling out. But there's still 197 countries that are signatories to the Paris Agreement, and they've all also had to make commitments to reducing their emissions, nationally determined contributions.
But the point here is that this is a global problem, and if one were going to solve it, you would have to also think very carefully about why Canada would then arguably have regulations limiting the use of coal nationally, but still not have any constraints on exporting coal to other countries around the world for them to use it.
Or encouraging the substitution of liquid natural gas.
Well, Canada has been doing that
It has?
through the LNG pipeline.
Yeah. Okay.
So these sound like a lot of policy choices then that are being made.
Right, yes, and so I think we've got quite a bit off track. I mean, this came to a question is what else has Canada done? So these are other steps that Canada has taken using its jurisdiction to try to reduce nationwide greenhouse gas emissions. At the international scale, there are international efforts to get off coal and to encourage countries to get off coal. I can't give evidence to this court, but
The question,
Canada can only control what happens in Canada.
well, Canada actually can control what happens in other countries too, by reason of what it exports or imports from other countries. Arguably, that would be the case too. The power of a country isn't limited to what goes on domestically. Is it not the federal government has the jurisdiction to deal with imports into Canada of products?
Yes, it does.
And is it not the federal government that has the jurisdiction to deal with exports from Canada?
Yes, it does.
So what we import and export clearly has effects on what's going on around the world.
Right, but the issue before the court is the validity of this act.
Pardon me?
But the issue before the court is the validity of this act.
It is the
And
validity
whether-
of this act, but the question was, you're putting forward an argument here that says, here's the purpose of this legislation, and I want to buttress that purpose about how serious this is and the transformative effect by reference to evidence which shows the magnitude of the problem. But you're putting this problem as well in a global context, not just a national one. And in the global context, it would appear that there are steps that could be taken by Canada, had Canada chosen to do so. And all we're simply raising is whether this is a case of policy decisions being made about which policy levers will be pulled and which ones won't be pulled.
This is not about a policy decision. This is about Parliament enacting a piece of legislation that, in its view, establishes minimum national standards that are integral to reducing nationwide GHG emissions. It doesn't mean that there aren't other integral steps that Canada could take, and in fact, Canada is taking some of those steps as set out in the evidence. It doesn't speak to what Canada will do in the future, but it is saying that Canada says that in order, as part of the dimensions of this problem, the national dimensions of this problem, that establishing minimum national standards for measures that are integral on an evidentiary basis before Parliament, so that Parliament has a rational basis to act, integral to reducing greenhouse gas emissions nationwide, is a matter of national concern now, given the dimensions of the problem. I'm going to move on to a little bit more domestically now. Yesterday, Chief.
This is probably then a good time for a break for lunch.
Yes, and then I'm
Because
going
it's
to
just
have to
12:30.
wrap up characterization.
I'm sorry, is there something that you wanted to refer to that would take?
No, this is a good space for the break. I'm just noticing my time, and
In relation to the characterization topic too, I assume that in this initial process that you're engaging here, you're going to reach Moffat's evidence in, I think it's paragraphs 97 and all that, about why pricing is the technique that has been chosen? Because the preamble says, it's behavioral change, and it's whereas the pricing of greenhouse gas emissions on a basis that increases over time is an appropriate and efficient way to create incentives for that behavioral change. So that's the technique that the Act has chosen. It's not chosen, we've discussed the alternatives, and you're saying, well, the alternatives don't matter, we go on this Act.
Yes.
And what this Act does is behavioral change by pricing, and that's addressed in Mr. Moffat's affidavit, and he talks about consensus. Were you going to cover all that, or were you just going to leave that in the record?
No, I was actually planning to cover
Okay.
that, although I had sort of allotted about an hour of my time to characterization, and I see I'm about 50 minutes into my time already, so.
Yeah. So, I mean, I'm not suggesting that you have to. I have read it.
I will certainly touch on it, but I'm going to have to truncate some of the discussion, because I think it's also
Sure.
very important to help this court understand the Act, which we say, I mean, it could achieve its purposes without the federal pricing system operating anywhere.
Yeah,
That
and you'll make that point.
essential
Right?
character is that it protects against provincial provinces resiling from a system that needs to apply throughout Canada in order for that system to function properly, to avoid against negative interprovincial and carbon leakage risks. So I will certainly get to that after lunch. and begin by trying to answer Chief Justice Fraser, your question yesterday about what happened between the Vancouver Declaration and the legislation.
Yes. Okay, well, thank you then so much. We'll reconvene at 1:30. Thank you.
Order in court.
Please continue.
Yes, thank you, Chief Justice. So as I said before the lunch break, yesterday you asked what happened from the Vancouver Declaration to the enactment of the Act. And just before the break, Justice Watson, you asked if I was going to discuss the evidence in Mr. Moffat's affidavit. I'm going to, the evidence in Mr. Moffat's affidavit helps answer those questions. In short, what happened after the Vancouver Declaration is there were 4 joint federal, provincial, territorial working groups that came out of the Vancouver Declaration. One of those working groups was the Working Group on Carbon Pricing Mechanisms. That working group, I reiterate, was a joint working group that had participants from all of the provinces and territories, as well as from Canada. And
So, by the way, you may recall, and you probably were a little puzzled when I talked about going outside the preamble, but I take it, is it Canada's position that the preamble on this topic, this specific topic of why you picked pricing, Canada did, that the preamble is insufficient, and therefore you're forced to turn to Moffat and that evidence to justify the pricing model? Are you saying that?
no, we're not saying that the preamble is insufficient. We're providing the court with the full context.
Right.
What it is that lies behind those 16 paragraphs in the preamble, because 16 paragraphs cannot cover 2 years' worth of work domestically, as well as international developments since 1992.
Okay.
You can't capture that in 16 paragraphs in the preamble, no matter how well they're written.
And you're also saying that the cases say that you are required to produce both intrinsic and extrinsic evidence, and we've got the preamble for the intrinsic evidence, and you're simply telling us and there's a bunch of extrinsic evidence. I want you to pay attention to it.
Yes, there is a lot of extrinsic evidence as well. And in this case in particular, that extrinsic evidence is specifically brought into being part of the intrinsic evidence by being referenced in the preamble.
And that includes all the treaties and everything that's happened internationally, because although that may not be allow unilateral action by the government federally, it does put the context and the purpose and everything in a larger context that that you're relying on.
Right, and it speaks to the national dimensions of the problem, and it speaks to the constitutional transformation, how different things are today than they were in 1867. When the
So
Constitution.
you had the 4 working groups from the Vancouver Declaration, and then where does that take us?
Well, so the work of the carbon pricing, the working group on carbon pricing, is particularly important, and I've got some extracts of their report at tab 15, and it's particularly important for many reasons. One of the but I'll point to 2. One of those is that in the extract that's there from, which includes A 2,630 and A 2,633, it demonstrates that there were 3 different scenarios that were modeled. And one of those scenarios, none of these are the scenarios that were ultimately enacted, but each of those are scenarios that show price starting at $15 and rising to $30 in 2030, one starting at $30 in 2018 and rising to $40 in 2030, and then one starting at $30 in 2018 and rising to $90 at 2030. And it did show that each of those scenarios reduced carbon emissions. So there was concrete evidence that carbon pricing throughout Canada would reduce nationwide carbon emissions. The other, actually there's 3 points I want to make. If you turn to A2639, one of the other things that's important is that part of the development part of the work of the working group was not just the pricing, but how to address the impact of that pricing and what to do with the revenues in order to address that impact. And so there is a discussion of revenue recycling, of addressing household equity impacts, of returning the money back into the economy, and how that would affect and be part of the policies. So the climate action incentive is part of what was done in the working group, which was again, I emphasize, this was a joint consensus federal, provincial, territorial working group. The final point I wish to take from the working group's final report is at A2655. And there are, ultimately the working group came up with principles. And the number one principle, and remember, this is a joint document. The first principle is that it should be flexible and should recognize and support existing carbon pricing policies already implemented and developed by provinces and territories. The provinces wanted to have the existing carbon pricing. Alberta had carbon pricing since 2008. This would have been an important principle from Alberta's perspective, as well as from BC's perspective and from Quebec's perspective, all of whom had carbon pricing, and it would have been important from Ontario's perspective, who was planning to implement a cap and trade. I go to the third bullet. There was agreement in principle that carbon pricing coverage should be applied broadly so that the incentives it provides to reduce greenhouse gas emissions is applied to as many goods and sectors in the economy as possible. And I think I actually take issue with Aida saying it doesn't apply to that many sectors. The Act as a whole, Part 1 and Part 2, where the federal carbon pricing applies, or in provinces where the provincial systems meet the federal benchmark, which I'm about to get to.
My understanding, though, staying on page A2655 and this working group, this particular document, the final report, my understanding, and perhaps it's not correct, but based on the submissions we received, was that the working group conclusions involved the provincial governments having the flexibility to design their own systems.
Yes.
And in that regard, on page A2655, under the fourth bullet, it says the First Ministers recognize that the federal government has committed to ensuring that the province and territories have the flexibility to design their own policies to meet emission reduction targets, including their own carbon pricing mechanisms, supported by federal investments in infrastructure, specific emission reduction opportunities, and clean technology. So certainly at the time of this working group, there seemed to have been a common understanding that the provinces would have that flexibility.
So two comments on that. First of all, that is one of the principles coming from the Vancouver Declaration. So those were the principles that came from the Vancouver Declaration, and then the working group said, in keeping with these principles,
Put it in.
First Minister's principles, we have then developed in our work here principles for carbon pricing. I will say, yes, as I go through the benchmark, you will understand how there is flexibility for provinces, including Alberta, which had carbon pricing that met the federal benchmark, and which has just changed its industrial pricing system, which has also been adjudged to meet the federal benchmark. So there is still flexibility. But you also see the second bullet from the bottom. One of the other principles that was agreed to, carbon pricing principles should minimize competitiveness impacts and carbon leakage. In this regard, carbon pricing policies in Canada, including explicit and implicit pricing mechanisms, should be reasonably comparable in price or synergy across the country to mitigate such impacts between provinces and territories.
Yes, and the next sentence is probably most important as well, equally important. Those carbon pricing policies should also be designed to mitigate international competitiveness and carbon leakage pressures.
Yes.
So there's a recognition that we're not just dealing with what is going on within Canada. When you're dealing with pricing of carbon, you also have to be concerned about the mitigate to ensure international competitiveness and avoid carbon leakage as between Canada and what could happen here in terms of the competitiveness of Canadian industry vis-a-vis industry in other countries.
Absolutely, and that is exactly why the three-stage process that Ms. DeMarco spoke about this morning for determining the output-based standards for the various industries was undertaken. Those output-based standards were set at a level to take into account the international competitiveness impacts. As far as in Alberta, honestly, the federal system was modeled after Alberta's system.
But the
And
point,
Alberta's system does the same thing.
the point here is that after this working group issued the report, it appears, at least from the perspective of your colleagues, some of your colleagues on this side, that there was nothing, that the next step was the unilateral imposition of certain numbers. So was there some gap in between that would explain how we went from what appears to have been a joint commitment to proceed with the provinces having the flexibility to design their own policies to meet emission reduction targets to a federally imposed system?
Well, the two are not mutually exclusive. And what happened next after the working group is it led to the Pan-Canadian Framework, which is the first minister's agreement. Again, this is not Canada imposing. This is a consensus document, the Pan-Canadian Framework on Clean Growth and Climate Change. It is a first minister's agreement on what the various levels of government will do. And in that Pan-Canadian Framework, and the extracts are at tab 17, in that Pan-Canadian Framework, it imported the principles from the working group, and it also annexed the provincial plans for carbon pricing. And when this document was signed, Alberta was pricing carbon through Alberta legislation exclusively. Ontario had a cap and trade system. BC and Quebec, who still have the same systems they had in place at the time, I think BC's actually involuntarily increased its stringency above. But when this was signed, part of the agreement for those provinces coming in and agreeing to that is that other provinces would be brought aboard as well. I can tell you that those interprovincial competitiveness impacts were a concern, are a consideration that Alberta takes into account. I have at tab 27 an extract from the cross-examination of Mr. Savage, and it's a discussion of stringency, and actually this was my friend Mr. Morley's questioning of Mr. Savage. And we say, and one thing you said there at the very outset is sometimes even facing the competitiveness issues, a jurisdiction just has to be able to go forward and do something. Answer, yes. But that jurisdiction that does something, if it's more stringent than the surrounding jurisdictions with which it's competing, it's paying something of a price for that. Answer, yeah. Clearly, Alberta was one of the first jurisdictions in North America to come forward with a carbon pricing policy on its large emitters. And the policy conversations at that point in time was that we're penalizing our economy to achieve an environmental outcome when some of our competitors are not. And that was an important consideration. And it shaped the nature of the policy instrument that we chose. And it shaped the stringency of the policy instrument that we chose and how we chose to implement it. And you see on the next page, there's another question. And the answer to that is, I would say that it's an important consideration. Where we start and where we end up are likely two different things. And that would be based on a number of factors, including what's happening around us nationally and internationally. When the Pan-Canadian Framework was signed, Alberta and Saskatchewan share many industries, and Alberta was pricing and Saskatchewan was not. At the time, it would have been in Alberta's interest to have, as part of the Pan-Canadian Framework, an agreement that the federal government would implement a pricing system that would operate as a backstop. And in fact, that was annexed to the Pan-Canadian Framework. It was part of that agreement. And that's at A2966. And this is the first iteration of the benchmark. And this is, again, the benchmark is very important to understand. I have more of it set out, the second at tab 18.
Did everybody sign the benchmark, this Pan-Canadian Framework? Did everyone sign the framework?
Everybody except Saskatchewan.
Saskatchewan did not.
Saskatchewan did not sign.
So the other provinces, at least at that time, agreed to it, but Saskatchewan didn't agree.
Correct.
And I assume and understand that Saskatchewan did not agree on the basis that it wished to retain the ability to set its own standards in accordance with the principles for a pan-Canadian approach originally agreed on in Vancouver Declaration and later subsequently incorporated in the Working Group on Carbon Pricing Mechanisms final report.
Saskatchewan objected to pricing.
So they obviously understood that working group and the Vancouver Declaration would allow them that flexibility and considered that the framework did not provide it.
That's correct. So Saskatchewan did not join the framework, all of the other provinces.
But just to be clear, they didn't do it because in their view, it was inconsistent with what they had understood was the flexibility which would be given to the provinces in accordance with the original Vancouver Declaration and the later working group.
They are the only province here today that has consistently objected to the federal carbon pricing system as a backstop. And that's the important next step that I want to talk about. And I think this is the really an essential feature of the Act is the benchmark, which is described in detail in paragraphs 83 to 88 of Mr. Moffat's affidavit. I've reproduced it for you with the sort of the supplemental benchmark guidance. The benchmark with guidance document at tab 18 that sets out, and this is where you get some amount, where you get the flexibility. Yes, there are standards that ensure comparable stringency throughout Canada. The minimum national standard is not, it has to be the same everywhere. It's that it has to meet a comparable level of stringency so that there's a similar pressure on reducing greenhouse gas emissions through a price signal. So it allows for cap and trade in Quebec. It allows for British Columbia's system. It allows for the hybrid system that Alberta had, which was a fuel levy and industrial pricing system. And it sets out here in this document how the provincial plans will be assessed against this benchmark to meet that objective of reducing the negative interprovincial impacts between provinces. One is the scope of emissions, a common scope that it will apply to substantially the same scope of emissions that BC's system applies to. And then it speaks about the two systems and how they work. So an explicit price system, the price per ton needs to increase by $10 per ton up to $50 per ton in 2022. It explains, and this is the important piece for on page R780.
And which tab are you at?
I'm at tab 18.
18. Thank you.
On page R780, 1, 2, 3, the third bullet down. And this is, so here it says, additional guidance on explicit price-based systems similar to Alberta's hybrid system. Actually, it says, sorry, that's not the third bullet down, that's at the top. So this is talking about systems that are modeled on Alberta's system. The third bullet down then, jurisdictions may tailor the emissions intensity standards in the output-based pricing component of their hybrid system to the circumstances of their sectors. These standards should be at levels that drive improved performance in carbon intensity over the period and should account for the best-in-class performance. The review of carbon pricing committed to in the pan-Canadian framework will consider the adequacy of these emissions intensity standards, accounting for their impacts on emissions, innovation, competitiveness, and carbon leakage. It has to be at a level that drives emissions reduction. Well, as we know, Alberta, there's a few things about the output-based price. Actually, sorry, I'm jumping ahead a little bit, but I think this is a good place to address a mistake that was There's one point I wish to clarify right now. This is the fact sheet from Alberta's website on their new tier regulations, their technology, innovation, and emissions reduction regulations. And it explains how Alberta has done their benchmarking. And the 2 points I wish to flag is because yesterday I understood my friend from Alberta saying that the 80% standard applies in Alberta industries. And that is simply incorrect. To be clear, the federal output-based pricing system does not operate in Alberta. Part 2 of the Act does not operate in Alberta, will not operate in Alberta, because Alberta's own new system, just like its old system, has been adjudged as meeting the federal benchmark. Alberta set their standards in a way that is flexible to recognize their specific industries. And you'll see they talk about facility-specific and high-performance benchmarks. For the
Let me actually ask you about that, in that it's true that this arrangement now means that Alberta takes the money in rather than the Canadian government, right? Why is it, how can you say that that's not applying the Canadian standard if what Canada has done is accepted the Alberta standard as acceptable to it, and therefore it's a Canadian standard?
I'm not saying the Act is operating. I'm not saying the Act is not operating. I'm saying the federal pricing system is not being applied. So under the Act, and this is what the Act is about. This is its essential character, is that it sets a minimum national standard for, in this case, a pricing system. It's a system that Parliament believed was integral to reducing greenhouse gas emissions, and there was lots of evidence before Parliament that it would do so. But the Act can achieve its purpose without the federal pricing system operating in any province.
Well, it can't, because if it didn't have the law to say that they could backstop in, they couldn't do it. It couldn't achieve its purpose because people wouldn't have to comply with it. Provinces wouldn't have to comply with the Act.
No, so this is where I'm going to actually, obviously going to get to the Act. The Act could achieve its purpose if every single province had its own provincial pricing system.
And did exactly what the federal government told them to do.
But it'd have to meet the benchmark, but the
That's
benchmark
right. That's what a benchmark is.
Yes, but the benchmark provides quite a bit of flexibility. It allows for very differing systems as long as they have comparable stringency. So
Well, then how can you say it's stringency if it's flexible? Stringency means you have a standard, nobody goes past it. That's to cross the wire is death. I mean, that's what you got. So it's either a stringent system or it's not.
Right, but there is flexibility in that, as I just read, in that the stringency means that there has to be a sufficient price. It has to cover the appropriate scope of greenhouse gas emissions. And 2, it has to meet the price, the emissions reductions objectives. So you can do it through a cap and trade, where the caps are declining and getting lower every year. In a cap and trade system, the market controls the price. If all the industries are really effective at reducing their emissions and increasing their efficiency, then the price of the compliance certificates doesn't go up a lot because
the money doesn't move around. But see, it's very important from the statutory construction point of view, it seems to me. If the legislation says it's imposing a stringent system, then whatever steps that it does better be a stringent system, or it's not even acting for its own purpose. In other words, the Act is not being served by itself.
So
You see what I mean?
the benchmark provides the way of comparing stringency from province to province.
Right.
The Act itself, I'll go to section,
We have it here, yeah.
tab 1. It's in the 166 area.
Okay.
There you go. 166 sub 2 is sub 3.
Right.
So the Act, instead of working like a lot, there's many pieces of federal legislation that apply the federal system but allow for stand down through agreements with provinces if provinces enact similarly stringent regulations. The coal-fired electricity generation regulations are an example. There's an ability under the Canadian Environmental Protection Act for provinces to enact their own legislation in relation to managing their coal-fired electricity generation facilities for the purposes of phasing it out. And if the government judges the provincial regulations to be sufficiently in line with the federal regulations, then they can enter an agreement where the federal regulations are stood down. So that applies the federal regulation unless the province can show that it has its own regulation directed to its own head of power that achieves the same purpose. Here, the converse is true. The federal pricing system doesn't apply in any province unless a province's system is not adjudged to have been stringent enough. And the decision, and this is what says the key part, for the purpose of ensuring, this is 166 sub 2, it's on page 163 of the legislation. For the purpose of ensuring that the pricing of greenhouse gas emissions is applied broadly in Canada at levels the Governor and Council considers appropriate, the Governor and Council may, by regulation, amend Part 1 of Schedule 1, including, and this is by adding or deleting a province. In Factor 3, in making a regulation under subsection 2, the Governor and Council shall take into account as the primary factor the stringency of provincial pricing mechanisms for greenhouse gas emissions.
So that's not a decision, though, that they must do something. It's a decision to take something into consideration. See, that's the, I think you're right. It's very, very effective what you're doing, believe it or not. You may think you're at sea here, but you're not. But this leads into what the Canadian Taxpayer Federation was talking about. They're saying that despite what is in 165 about net amounts and so forth, which also has discretion built into it in our subsection 2, this is a discretionary system built under regulation. It is not stringent. It is what we say from time to time goes. And so my point is, my question I suppose is, how can this be characterized as a stringent bottom line, baseline stop, no below, if that's what you have? I mean, and remember, the act is under attack by the question overall, but most of the time you get legislative attacks is on one subsection of something or other.
So this is the regulatory framework. First of all, the fact that the act can achieve its purpose of having emissions pricing apply broadly throughout Canada without the federal pricing system ever applying in any province, that would be ideal. That would be fantastic.
But that's not what's happening. And I know that there have been arguments to the effect that, look, this is, you can do what you want in the provinces and it really doesn't have a compulsory aspect to it because you're free to do what you want. You're not free to do what you want. I mean, and you're not surely arguing that because unless they meet the minimum standards that the federal government says, it's not going to be approved.
I'm not saying there isn't a compulsory aspect to this. I'm saying what I would, in answer to Justice Watson's question, I was pointing out that, yeah, the Canadian Taxpayer Federation said it's discretionary, but
isn't it? Is it discretionary or not?
It is discretionary, and we know from the, but primarily based on the stringency of the pricing system.
What is the adjective? What primarily based on? What does that mean? I mean, it's a discretionary or not? You say discretionary? Okay.
It is discretionary, but in the entire lead up to the act, we know that discretion is being exercised based on the benchmark criteria. There was, in the evidence, you will find the letter that was sent to all of the first ministers by Minister McKenna and Mr. Morneau.
By the way, is that letter was after the act?
It was, well, yes, it was.
Okay, so let me stop you there then, because as a matter of constitutional principle, I realize that under, pepper and heart and all this, you can look at, as you have, you can look at debates in the legislature, you can look at debates in Parliament to interpret the purpose of an act. You can look at preambles. How can you look at post-enactment expressions of opinion by any state agent or any minister of the Crown to interpret how this law works? The Americans don't even accept that.
I actually am going to correct myself.
Okay.
Look at paragraph 107 of
Okay.
Mr. Moffat's affidavit.
Right.
That letter was sent December 10th, 2017. The act was to explain how the benchmarking process was going to proceed.
Okay.
The stringency assessment would proceed and that it would be based on the benchmark. No province, every province in this country understood that the stringency assessment was going to be based on that benchmark. And in fact, yesterday when Mr. Gall said, I haven't seen any indication as to how the decision was made, well, if you turn to tab 2, this is the regulatory instrument listing the provinces where, in this case, part 2 was going to be applied. And if you turn to the regulatory analysis impact statement at the end, the last 2 pages at tab 2, there's 2 annexes. There's the provinces and territories with existing or planned carbon pricing systems. It lists them, and then it lists the various criteria that were in the benchmark. Do they meet it? Do they not meet it? Then on the next page, at 3776, provinces and territories without existing or planned carbon pricing systems. So there was no confusion about how the benchmarking exercise, how the stringency assessment exercise was going to work.
I would actually like to follow up on your comment about the act being discretionary. Is there anything that suggests that the government wouldn't then have the authority to change the methodology for how it applies stringency and the standards and the industries to which it applies and anything else you can think of? Because it looks to me as if there's a lot of discretion built into this, and there is no guarantee that what it is today will be what it is tomorrow.
Well, a lot of that discretion is because it's a very complicated system. So perhaps we can spend just a little bit of time on how the Act operates.
I'm less interested in how it operates today and more interested in whether it confers a degree of discretion on the federal government that allows the federal government to change the basis and terms on which it's to operate. So that's the question. That's what we're really looking at here, because I think my Lord Watson made the point earlier, when you talk about the effects, we're not talking about the effects in the sense of, is this good or is this bad? Will this work out to the advantage of certain industries in Canada now? Will it not work out to the advantage? Can you come back later, as someone has suggested, and argue that the effects are more punitive than originally thought? And perhaps at that stage, because they might trench on a section of the Constitution. We have to deal with the legislation today. So when we look at the effects, we're looking at what is the downstream effect in terms of the basket of steps that could be taken to implement this regulatory framework. So when you say it's discretionary, what I'm asking is, does that allow the federal government to change aspects of this framework, that the benchmarking that's currently in place? So does it allow it to add industries? Let's ask the question this way. Yes or no?
Presumably, yes.
Pardon me?
I would believe, I believe, yes, the answer is industries.
So it can add industries. Could it remove industries?
It could probably remove, yes, it could remove industries. It has exempted, for example, the agricultural industry
And in theory, that could be added tomorrow then. They could add that in under this scheme. Am I not correct?
That is correct. It could
Nothing
be
to
added.
prohibit that. They could add agriculture tomorrow. Can they change the rates at which the amount is taxed, or pardon me, the charge is levied? Can they change the numbers from X?
What we know about that, based on the evidence that is before this court,
Yes.
is that the price is going to increase to
Yes.
$50 a ton by 2022, and that there will be a federal, provincial, territorial review of carbon pricing by 2022 as part of the Pan-Canadian Framework Agreement, and that there will be an assessment of the.
That's
Yes.
like a contractual agreement
Yes.
though between the
So the
governments.
answer is, short answer is yes.
Irrespective, that's right, irrespective of any planned meetings to chat about how things should happen, the discretion falls within the federal government to increase the amounts as it sees fit. Is it so?
Well, in theory, yes, but part
Well,
of, no. Yes, the answer is under the legislation, yes, but there is more than just pure law, of course. I understand that we have to assess the constitutional validity of the legislation, but you have to look at all of the work that went into developing this legislation to work cooperatively with the provinces and all of the work that is continuing.
But that was before, the cooperation part was before the legislation was imposed. So perhaps the provinces thought, or some of them did, as Saskatchewan, that it would continue to give them the flexibility, but it doesn't. So the issue comes back to, and I thank you for your candor in acknowledging that the numbers could increase, because that is certainly appears to be within the discretion of the federal government. If the validity of this, if the constitutional validity is upheld, then I do not see anything here, unless I'm wrong, I'd like you to tell us, which would prohibit setting higher and higher standards. Or to put it another way, it prescribes a minimum, but it doesn't prescribe a maximum. It's not limited by any maximum, is it?
No, it's
not.
Well,
So-
only through democratic process.
So, well, not even the democratic process, unless you're talking
Well,
about
it's-
repeal
this
of
process is the
legislation.
governor and council, that's not democratic.
This one prescribes the governor and
No, election
council.
is.
Oh, yeah, well, I guess you could say an election would
It's the ultimate form of
create us a
democracy.
lot of people. Yeah.
I do just have one correction. I was mistaken about agriculture. It cannot be added by governor and council discretion. It's actually an exemption that is explicitly in the act itself.
I'm sorry, but I understand it's an exemption under the act, and I do recognize that it's in the body of the act, but there's nothing to prevent the act being amended tomorrow by Parliament. Am I correct?
Right, but that would require an amendment of the act by Parliament.
Okay, but that's by
Not-
Parliament. The point
not
is
a
that it's.
discretion.
No, but the point is, it's not an amendment by the province of Saskatchewan to accede to it on the agriculture. It's an amendment by the federal government to add agriculture, even if, for example, Saskatchewan objected. Is that correct?
Correct.
Okay. All right, well, I think we have a fairly good understanding of the degree of discretion. Where do you want to move to
Well,
next?
I'm just going to spend just a little bit of time on the act itself, because that is the intrinsic evidence. And first, I want to say we certainly disagree with Saskpower that the pith and substance of the act is the regulation of provincial non-renewable natural resources or development, conservation, and management. There is no question that the act will undoubtedly have effects on provincial powers, as federal legislation may do. But we know that the act is not, or in Canada's submission, the act is not in pith and substance related to 92A. The act applies to a wide scope when the federal pricing applies.
I'm sorry, you're saying it's not related to Section 92A, and how would you make that connection that it's not related to Section 92A, which confers on the province's exclusive jurisdiction for the management of their natural resources, which must necessarily, arguably, include the terms and conditions under which the facilities approved by them will operate in the province? So how is there no connection between what the federal government is imposing on those industries and what the province could impose?
Well, so the province could impose its own in-province pricing system, but all of the provincial powers are limited to operating in the province, including 92A in the province. This legislation, its essential character is to ensure that pricing applies throughout Canada, and pricing applies to far more, to more than just the province's management of their natural gas. It doesn't tell them how to manage, in fact. It applies a price to the emissions, but they make their own decisions about how they respond to that effect from the.
I thought we'd already gone through that once you set a certain standard, their ability to take a different approach to how the industry is to operate is going to be thereby negatively impacted, because the federal government has set certain standards which it says is mandatory vis-a-vis the operation of those industries. And I know that the argument is, well, you could do better, and therefore, there'd be no impact at all of the federal requirements if you did better, or you did at least as well as the federal government says in that area. But to suggest that that doesn't impact on the ability of the province to determine how best to manage its natural resources and the development of those resources, I'm finding it very difficult to understand that argument, which is essentially what you're saying.
The act is not in pith and substance related to, that is not its essential character. Its essential character is not management and conservation and of electricity generating facilities. Its essential character is to ensure that pricing applies to a broad scope of emissions throughout Canada, including from various other processes such as the cement industry, for example. And we saw from the extract that Aida handed up earlier today. It's also in the record, but it applies to potato processing, mineral wool, oilseed processing, wet corn milling, alcohol distilleries, citric acid, sugar, isopropyl alcohol. It's ensuring that pricing applies throughout Canada to a broad scope of GHG emissions sources. It's not just specific to...
But it's not the question of whether Canada's act is intended to in effect, take over 92A. It's that it impacts 92A.
But that's okay.
It's okay.
Under constitutional law, that's okay. Because there has been so much discussion about 92A, I pulled up just an extract from a case that I don't believe is in the Book of Authorities.
Okay.
But it's Quebec versus Moses, a 2010 SCC 17. And it was about the approval of a vanadium mine project. And it's at paragraph 36 of that judgment. There is no doubt that a vanadium mining project considered in isolation falls within provincial jurisdiction under Section 92A of the Constitution Act over natural resources. There is also no doubt that ordinarily a mining project anywhere in Canada that puts fish habitat could not proceed without a permit from the federal fisheries minister.
That's by operation of the criminal law power.
Fisheries.
Or fisheries, one or the other. There's a specific constitution. It's not the national concern thing. That's a specific thing.
Right, but then the national concern doctrine is also arising out of the written Constitution as it was written in 1867 and interpreted through the courts since then.
Well, could we perhaps, I just would like to make a note, because I asked Alberta this, and I just would like to clarify Canada's position. On the pith and substance, what do you say then is the pith and substance of the legislation in question?
We say that the pith and substance of the legislation is to establish minimum national standards integral to reducing nationwide greenhouse gas emissions.
Minimum national standards that are integral to reducing nationwide greenhouse gases. Okay, so now I take it, let me just clarify this, because as I understand, the initial argument before the Saskatchewan Court of Appeal on behalf of Canada was that the pith and substance or matter, and I take it you would agree, matter and pith and substance, matter for purposes of national concern and pith and substance, I assume you would equate from what you're saying.
Yes.
So as I understand it, Canada's argument before the Saskatchewan Court of Appeal was that the pith and substance or matter for purposes of national concern was greenhouse gas emissions.
It was in our initial factum.
And then, I just want to clarify, because that's, if I can finish my question, you can then explain what your current position is, but I just want to set the scene for it, that I understand that was in your initial factum then and initial argument of greenhouse gas emissions. And then it shifted and morphed, and I'm not sure when, because we weren't party at that part of that litigation, to cumulative dimensions of greenhouse gas emissions, according to the majority judgment in the Saskatchewan Court of Appeal. And then the Saskatchewan majority judgment decided that this could be upheld on the basis of the matter being the establishment of minimum national standards of price stringency for greenhouse gas emissions. And then the Ontario Court of Appeal majority decided that it could be upheld on the basis of establishment of minimum national standards to reduce greenhouse gases. And Justice Hoy adopted the approach taken in Saskatchewan and went for the narrower formulation of the matter. And your factum now and today, consistent with what you've said, is that the matter is establishing minimum national standards that are integral to reducing nationwide greenhouse gas emissions. And I guess that what I would like to know is that Canada's final answer on what its position is.
That is Canada's final answer.
Okay, all
Now,
right.
just to clarify a little bit, so in Saskatchewan, Canada has only ever intended to try to say that it has a national concern jurisdiction over the national aspects of the problem. And even if you went back to Canada's initial factum, you will see extensive argument in there about the important role of the double aspect doctrine and the continued room for provinces. We made those submissions. We received reply submissions, and we recognize that we may actually have created a double aspect problem by the label that we used, the subject matter label. And any inflation reference talks about subject matter labels. So before our oral submissions, and there wasn't an opportunity for written reply, in our oral submissions in Saskatchewan, we changed the phrase, how we defined the PIF was the cumulative dimensions. It was meant to capture the national dimensions of the problem all the way through. We're trying to capture Canada's national contribution to global greenhouse gas emissions and how Parliament can address that. We then get judgments from 2 courts of appeal. They cause us to look at the Act again, informed by those decisions. It seems reasonable that Canada should listen to what the courts have told us. And therefore we come before this court. But what we've offered to this court and what we have put in our Supreme Court factum, which is already filed, is that it is integral, minimum national standard, integral to reducing nationwide greenhouse gas emissions. And we have added to what we say are 2 qualifiers to the definition that Justice Strachey provided. And the 2 qualifiers are the addition of the word integral and the addition of the word nationwide. And that is a further attempt to try to limit the scope. The problem here is not that there isn't a national dimension. The case for the national dimension is overwhelming. Every emitted greenhouse gas emission goes into the atmosphere and mixes and contributes to the global problem. The atmosphere is indivisible. The problem is that the nature of greenhouse gas emissions themselves are so pervasive that our big challenge lies in finding the limits, in limiting the scope of Parliament's ability to address the national concerns while leaving the provinces with as much room to continue to exercise their jurisdictions, which is the challenge that we have been engaging in this case. We say integral means that Parliament has to act on a rational basis, on the basis of evidence, so that Parliament can't just say, oh, hey, maybe this is a good idea and proceed without there being real evidence in the Parliament process that gives Parliament the rational basis. We're not asking the court to engage in a policy assessment. We're asking the court to ask, did Parliament have a rational basis? And that is a normal part of constitutional litigation.
Here's the problem that I see. I'm so sorry to interrupt this point, but this is really an important one because you say now, and this is your final answer, that this matter is to establish minimum national standards that are integral to reducing nationwide greenhouse gas emissions. And that would be consistent, arguably, with doesn't differ very much from the majority in the Ontario Court of Appeal.
Correct.
Differs substantially from the majority in the Saskatchewan Court of Appeal. Your friends assert that you take the position that that's actually a more stringent test, but in point of fact, the Saskatchewan majority tied it to establishing minimum national standards of price stringency.
Yes.
The operative words, so there's no mistake about anybody here in the room, are price stringency. This wording now, establish minimum national standards that are integral to reducing the greenhouse gas emissions, has now taken that limitation, as it were, and it's gone. You're trying to uphold it, and there's no price stringency mentioned now. So in theory, not only can you now set price, but you can set a whole bunch of other standards as well. How much people, in theory, could, to take an example, follow up on Justice Wakeland yesterday, how many miles someone could drive or not drive, what kind of temperatures people could heat their houses at, what the minimums or maximums are, and maximum is that you can have your house heated to. All I'm saying is this has now gone way beyond pricing. You're into it looks on the face of it to be something far broader. It looks to be very much akin to your original submission of we want the power, we contend we have the jurisdiction to control greenhouse gas emissions generally in Canada. So if I'm wrong and you think that this is narrower than something that's linked to price stringency, please explain why it appears as if it's broader.
We're not saying it's narrower than price stringency. So we're on a continuum.
Yes.
There's the Saskatchewan Court of Appeal majority and Justice Hoy limited it to effective price stringency, the minimum national standards of stringency for pricing greenhouse gas emissions nationwide. The Justice Strathy and the three judges of the majority in the Ontario Court of Appeal said minimum national standards to reduce greenhouse gas emissions. What we're saying is that we have added, and because we think this is supported by the Act and the legislative process, we have added two qualifiers to that to incorporate this requirement for integrality. So it's not just any minimum national standard.
Actually, your friends dispute that, and I have to say I take you up on that also. I mean, the word integral means that it's now linked. It doesn't have to be even to reduce GHG emissions. All it has to be is integral to some process which reduces GHG emissions. How is that smaller?
Well, we're intending to capture what was reflected in the legislative process here, which here.
No, but is it smaller or is it bigger?
No, it's intended to be smaller.
It's intended to be smaller. Is it smaller or is it bigger?
This court can say it's smaller.
Defining
the matter is part of the court's. So when you are, as we know from the court's prescription, when we are engaging in a division of powers cases, as the court in Dagenet Transport or Wartsella just said, sometimes the classification stage requires considering the scope of the relevant head of power. This is one of those cases. Mm-hmm. The head of power ultimately is how you would define it. So if you don't like the word integral, just as the Saskatchewan Court of Appeal and the Ontario Court of Appeal chose a different way to describe the pith of the Act, you can replace that word, if you so choose, with a word that you think is a better adjective to capture what we are intending, which is that it is smaller. Not that it's just linked to greenhouse gas emissions, but that...
In fact, as I read your factum, I read the word integral as meaning necessary.
Yes.
And that is that any steps that the federal government takes must be absolutely necessary for the intended purpose. And therefore, that is narrower, not broader, than an alternate interpretation of integral, which means in relation to.
Right, and so necessary is maybe too far, but here the evidence was. The evidence before Parliament
But are you adopting that, by the way?
What's that?
Are you biting on that? Are you going with the necessary?
I'm
Thinking about it.
You're thinking about it.
Necessary is the right word either. But if you look at the evidence that was before Parliament, I take your point, but I take your point that integral has been used most recently in Dagenet Transport, in fact, which coincidentally came out after we filed our factum, where it's used as a way of drawing dividing lines. And really that's what we're saying, is a way of drawing dividing lines. So in the evidence in Parliament, in this case, they had before them estimates that carbon pricing throughout Canada, including the provincial carbon pricing systems, would reduce nationwide emissions by 80 to 90 megatons by 2022. That has since been updated since Ontario cancelled its cap and trade system, but what was before Parliament at the time, and this is at tab 22. Page R78, to give you a sense of what we're trying to capture when we say integral. It doesn't have to be to this magnitude, but this is what Parliament had before it, was that 80 to 90 megatons by 2022. Well, under Canada's current Paris Accord agreement, we have to reduce our greenhouse gas emissions. Canada, as a nation as a whole, has to reduce its greenhouse gas emissions by over 200 megatons between now and 2030. This got us almost halfway there, as it was when it was before Parliament, before the governments changed, legislation changed provincially. That was the information that Parliament had.
Well, can I ask you this, though? This business about integral, I realize I don't want to pin you on the thing, is you're a lawyer after all. Although I would draw though back to the earlier discussion I made about post-legislative opinions, even by state agents represented by lawyers, do not define the act either. And you're saying, no, well, it's up to you anyway, and that's fair. You said, okay, the courts, they have to do that. We're the repository of constitutional opinion, not you. So I get that. But the difficulty is, who decides then, ultimately in practical terms, on the ground, what is integral and or what is necessary? Is it the government of Canada that decides that? Presumably it is. They don't delegate that anywhere into the provinces, right? So the national concern standard that you're talking about that justifies this act, presumably on the test you've given, is something that the federal government unilaterally decides. They decide if it's integral or they decide if it's necessary, and if they decide that, and this is valid as a national concern, the provinces can whistle for it. Am I right?
I don't think we would put it in quite. But yes.
Yeah.
If you recognize that the federal government has the POG jurisdiction as a matter of national concern to implement minimum national standards integral to reducing nationwide greenhouse gas emissions, then the Parliament could introduce a different minimum national standard. That Parliament, on an evidentiary basis, that's what integral is meant to capture, that Parliament has to have before it an evidentiary basis for believing.
That'd be fettering, right?
Federal.
Parliament can't bind itself.
No, but
Parliament cannot, if they want to do legislation in the future, they can ignore completely all the legislation they've had in the past and all their agreements. They could override all of that.
right, but the rigor of the Crown-Zellerbach test, the pith and substance analysis, the weight of evidence, and the judiciary is the line that ensures that Parliament doesn't go rogue, so to speak. I mean, you're talking about ignoring all that, ignoring everything that's gone before, ignoring cooperative federalism, and
I think what Justice Watson is getting at is that if in fact this power to deal with a very difficult problem and a very dramatic problem internationally and nationally, and I don't think there's anyone that disputes the fact that this is a critical concern, and I think you described as existential threat, which again, I doubt that many people would disagree with where the United Nations has landed on this, or Canada, or the other countries that are willing to step up and try to do their duty and perhaps more. But I think the point that Justice Watson is making is that if in fact the constitutional jurisdiction is given under the national concern doctrine to establish the minimum national standards integral to reducing nationwide greenhouse gas emissions, there doesn't seem to be any end to where that goes. So where is the defined end? And I think the point being that we will get into the issue of how much does it intrude on provincial powers, but just at first blush, I think his point is it's so broad, there is no end limit. The Parliament could change that tomorrow. It could be, as we said earlier, and I think you conceded, they could add industries, they could delete industries, they could change the amount, they could increase the amount dramatically. They could actually do something other than using pricing. They could do a combination of other things as well.
so the limits are in the definition of the matter to begin with, the integrality. Minimum national standards, there's basically, minimum national standards is, came out of the Securities Act reference. It's that paragraph, oh, no, I was going to say paragraph 55, but paragraph 55 is of the securities reference, which is at tab 32 of Canada's book, is the paragraph about inherent in a federal system is the need for an impartial arbiter of jurisdictional disputes, and that is this court. The idea of minimum national standards, though, also came from the securities reference. Thank you. It's that paragraph 114 of that decision where in the securities reference, the Supreme Court's in not upholding the first Securities Act, which this court is very familiar with, said legislation aimed at imposing minimum national standards applicable through the country and preserving the stability and integrity of Canada's financial markets might well relate to trade as a whole. Well, here we're saying
that's a trade and commerce issue.
That is a trade and commerce issue. But here we're saying we're because the last case that really seriously considered the national concern doctrine was Crown-Zellerbeck, and I'm going to get into the prudential inability test very shortly. But that minimum national standards that are applicable throughout the country aimed at this stability. So that the other part of this definition, one, by taking the minimum national standards approach, it first says provinces have the ability to do what they're doing. Because there's still some variability, you have to admit that the benchmark allows for variability because Quebec and Alberta and BC have different systems that each meet the minimum standards of stringency, but they are sufficiently stringent to affect the interprovincial negative impacts of competitiveness and carbon leakage. But that's the other piece of it, is that nationwide, like saying nationwide, one, it's focused at the national level, but we say, and this court can say, that it incorporates the provincial inability test as part of, just as in the trade and commerce power, it is part of assessing whether or not legislation comes under that head of power. So, to take the lawnmower example, Mr. Justice Wakeling, whether Alberta does or does not prohibit lawnmowers will have no effect on whether Saskatchewan does or does not prohibit lawnmowers or Ontario or gas lawnmowers. Gasoline lawnmowers. Yes, we do want the lawns to get cut. But, and so the ability
but it would have an effect if the federal government decided, as part of their minimum national standards that are integral to reducing greenhouse gas emissions, that nobody was going to be using an electric gas-fired mower anywhere in Canada.
Well, not under the national concern doctrine, because what we're saying is that, and this is where the provincial inability test, properly understanding the provincial inability test is really important, because it's not just that we think you have to do this everywhere to reduce emissions, but that if it's not a system that applies throughout Canada, that there will be negative interprovincial impacts from one province to another. So in the lawnmower example, it's very much like heroin addictions treatment was in Snyder. If Ontario bans the use of gas-powered lawnmowers and Alberta decides not to do it, Alberta's decision to not do it is not going to affect Ontario's ability to do it, and it's not going to have a negative impact on Ontario with respect to that system, that measure. But for carbon pricing, we saw in Alberta's own witnesses' evidence that stringency from jurisdiction to jurisdiction impacts interjurisdictional, even at a national as well as international, but at a national level as well. So if BC has a price on carbon and Alberta has a price on carbon, but Saskatchewan does not, particularly when you look at Saskatchewan and Alberta side by side with many industries that are alike, the ability for Alberta to increase its stringency is impacted by the question of whether or not there is pricing in Saskatchewan, because even interprovincially.
Well, that reasoning though could make a national concern out of any pricing comparisons on any topics whatsoever across the country. It doesn't have to be gas emissions, it could be guitars, It could be anything.
But then the stringency of the test matters, because it's a three-part test. So.
Not too stringent, it applies to every single product that Canada produces.
But you're painting this
It's
as,
not a matter of national concern. There isn't a constitutional transformation that is required.
but you're painting this as a problem, but I don't hear Alberta saying that they object to Saskatchewan setting their own standards. In fact, I hear Alberta saying Saskatchewan is free to do it, and we don't believe that they're having the ability to do it and jurisdiction to do it in any way affects us. And I hear Saskatchewan saying the same thing about Alberta. So on your theory, they should both be on your side and say we need the minimum national standards, but they're not.
No, I mean, Saskatchewan is objecting. When the act was enacted, Alberta was not. In fact, as I said, the evidence in this case from Alberta's own witness is that interprovincial competitiveness was a factor that Alberta considered in setting its stringency requirements. Alberta's had pricing since 2008. When Alberta signed on to the Pan-Canadian framework, that interprovincial competitiveness impact would have been relevant. That is what's in the record.
Yes, but it's also in the record that Alberta imposed one of the first carbon pricing schemes in Canada, and they did it before Saskatchewan did anything, and I don't recall Alberta saying we're not going to do it unless Saskatchewan does it.
They made their choice to proceed, and that's exactly what Mr. Savage said. If we go back to tab 27, because Alberta has been taking steps to try to address its greenhouse gas emissions.
In fact, you've touched on something now that I think is very important. You're saying that this relates to the provincial inability test, which forms part of the national concern doctrine.
Yes.
Right. Is it the position of Canada that each province does not have the ability to deal with greenhouse gas emissions?
It is.
Are they unable to deal with it?
Each province is unable to deal with the national aspects of the problem, which includes they're unable to deal with another province's decision to not do anything.
It's a different issue.
And the impacts that it has on that province of the other province deciding not to do anything.
But why didn't they put in a pricing model which says that the government will simply calculate the differences between the provinces and level it all out? They didn't do that. They actually imposed pricing across the country. And you say that's stringent. Fair enough. But it's what it is. It's an alternative. They've made a policy choice to go on a particular alternative. A particular pricing model is built into the preamble and built into this statute. I'm not saying there's anything like deceitful about this or anything. It's just that the federal government is assuming provincial inability, but they've conceded by their own statute. There's no provincial inability. There's a provincial inadequacy. There's a provincial inconsistency, and that's why we're in.
There is a provincial inability. I'd like to take you back to what Mr. Savage actually said. I realize it took me a really long time to start to understand the economics of this. But so you see at that extract from at tab 27, you got Mr. Savage. The question is about competitiveness issues a jurisdiction is facing. And the question is, sometimes, even facing competitiveness issues, a jurisdiction just has to be able to go forward and do something. Alberta decided to do that. Alberta decided to just go forward and do something. But next question. But that same jurisdiction that does something, if it's more stringent than the surrounding jurisdictions with which it's competing, it's paying a price for that. And that's the answer. Yes, clearly Alberta was one of the first jurisdictions in North America to come forward with a carbon pricing on its large emitters. And the policy considerations at that point in time was that we're penalizing our economy to achieve an environmental outcome when some of our competitors are not. And that was an important consideration. And it shaped the nature of the policy instrument. And it shaped the stringency of the policy instrument that we chose to implement in the policy at the beginning. And well, next question, but this is important. In effect, you agree that you might not go for as much stringency as you would be able to do so if you knew other jurisdictions were also going to do it, or if you had some other measures to address competitiveness concerns. I would say that was an important consideration. Where we start and where we end up are likely two very different things, and that will be based on a number of factors, including what's happening around us nationally and internationally.
Counsel,
Yeah.
if you use the inability argument that way, could the federal government then look at pretty well any topic, any class of laws that exists in all the provinces, and then invoke the national dimension head of power? So if you looked at consumer protection legislation, there's consumer protection legislation everywhere. Could you then say, well, in Alberta, you can't enact a law that affects how consumers are dealt with in Ontario? Therefore, the federal government can do this, or any other topic. I would have thought inability would cover a different topic, because if all of the provinces dealt with greenhouse gas emission the same way as the Ottawa wants it to do, the problem would be solved, I would think, in the sense that the Ottawa standard would be met. There's going to be less greenhouse gas emissions. If all the provinces do what Ottawa wants them to do, the problem's solved.
And the provincial inability test means that it protects against the fact that any province is free to resile. The facts of this case demonstrate that. When the Pan-Canadian framework was signed, when the Alberta and Ontario had carbon pricing systems that met the benchmark, they resiled from that. Canada tried a cooperative approach, and that broke down. This is the same as occurred in Monroe, in the National Capital Region case. Canada tried a cooperative approach, trying to work with Quebec and Ontario for each province to make the municipal regulations necessary to create the National Capital Region, and one of the provinces wouldn't cooperate. So then Canada stepped in to address the lack of cooperation. But the answer is no, because you have to remember the national concern doctrine is a three-part test, right? So the first question, and maybe perhaps this is a good time to go to the Crown Zeller back.
I was going to take you to paragraph 35 of Crown Zeller back when you finish this question, because I think that that's the key to your position, and I want to know whether paragraph 35 is Canada's position, quoting directly from Ledane and Crown Zeller back.
I will certainly go to paragraph 35, but I'd like to first go to the raison d'etre of the national dimensions concern. It's a three-part test, and the first part of that test is what was captured in the decisions of Lord Watson in local prohibition and Viscount Simons in Canada Temperance Federation. And those were reproduced in the Crown Zellerback case, which is at tab 35 of the complaint. And that's at paragraphs 24 of that decision. The Lord Watson in the local prohibition case in 1867, and I point that date out because yesterday there was a suggestion that this was amending the Constitution. This case, the national concern doctrine is not amending the Constitution. It's interpreting the Constitution as it was written in 1867. And the national concern doctrine has been interpreted as being a part of Section 91 since very early on in Confederation. It has endured since Lord Watson's famous statement in local prohibition, "Their lordships do not doubt that some matters in their origin, local and provincial, might attain such dimensions as to affect the body politic as a whole, and to justify the Canadian Parliament in passing laws for their regulation or abolition in the interests of the Dominion as a whole." And you see then, and yes, of course, there's also the great caution part of that quote, which comes down to why the other parts of the test are. But this is the first hurdle. This is why it's not anything. There has to be that either a new matter, and we say, as the Ontario Court of Appeal found, that there is in fact a new matter here, that there was absolutely no understanding of greenhouse gas emissions and their effect on the global climate when the Constitution was enacted in 1867. But, and that evidence is in the record, and it's mentioned in our factum. But you see here so that is a first important hurdle. Even if it's not, if this court doesn't accept that it's a new matter, we say that it is, and the Ontario Court of Appeals said that it was. There's certainly the constitutionally significant transformation here that Lord Watson spoke about, and then Viscount Simon picked up in 1946. That is the raison d'etre of the national concern doctrine, and that is a first significant hurdle that has to be met before we even get into the question of, is the pith and substance of the legislation distinct, is recognizing it reconcilable? Before you even get into it, you have to ask the question, is the matter of that legislation, is its pith and substance a matter of national concern? Has its dimensions changed such that it is no longer a matter in the province? We say that this matter, as we define it, captures the aspects of the problem that are not in the province.
Can I get you to focus slightly differently? Yesterday I set out the questions that I've always understood apply in division of power. And the first one is, how does the law affect the behavior of those that are subject to it? And you've done an excellent job, along with your colleagues, in explaining to me how it impacts those who are bound by it. And then the next question is, does the challenge law reasonably display a feature that could be classified as a class of law under Section 92? And I think from what I've heard you say, you would acknowledge that the law challenge does have features that bring Section 92 into play.
Yes.
Property and civil rights.
In the province.
Yes. Local works and undertakings. 92A. So we've got at least three. So the provincial interest is engaged. Then the next question is, does this challenge law display a feature that can reasonably be classified as a class of law assigned to the federal government? And you are advancing the national dimension doctrine.
Yes.
And assuming you can meet that test, which you vigorously argued you can, then the next question comes in. And let me read to you what Professor Letterman wrote in 1953. And this, to my way of thinking, is the classic statement, never been bettered. And here's what he writes. So this is Professor Letterman in 1953 in a collection of legal essays in honor of Arthur Moxon. A rule of law for the purposes of distribution of legislative powers is to be classified by that feature of its meaning, which is judged the most important one in that respect. In this inquiry, the judges are beyond the aid of logic, because logic merely displays the many possible classifications. It does not assist in a choice between them. If we assume that the purpose of the Constitution is to promote the well-being of the people, then some of the necessary criteria will start to emerge. When a particular rule has features of meaning relevant to both federal and provincial classes of law, which we have here, then the question must be asked. Is it better for the people that this thing be done on a national level or on a provincial level? In other words, is the feature of the challenge law, which falls within the federal class, more important than the well-being of the country than that which falls within the provincial class of laws? Then he closes, such considerations as the relative value of uniformity and regional diversity, the relative merits of local versus central administration, and the justice of minority claims would have to be weighed.
Yes.
Do you take any issue with that analytical framework?
No.
So the key question for us then, assuming that you convince us that there is a federal class of laws here, and that would be the national concern doctrine under the residual power, we then have to decide which is better for the people of Canada, that it be done nationally or be done locally. And I would find it helpful if you could tell me, why is it that if all the provinces don't discharge their full jurisdiction, that the problem that's been identified by this legislation, which is there's too much greenhouse gases in the atmosphere produced by those subject to, those living within the territory of Canada. Why can't we let the Canadian provinces do that?
In that, there was an facts mattered. And early on, I showed the national emissions and juxtaposed it against Canada's national commitments to reduce greenhouse gas emissions. We have not been able to do so with Parliament exercising criminal law power and to the extent that it has. This gives actually a more flexible tool than command and control under criminal law power. It's
I'm
less,
sorry, I didn't catch that. You're saying that that's more effective? This is more effective than command and control, or this is command and control?
more flexible, less intrusive tool for Parliament to use, a jurisdiction for Parliament to use than command and control under the criminal law. So it's actually, this legislation would be less intrusive than classic command and control. Now, I know my friend from the Canadian Public Health Association is going to argue that there's enough prohibitions in this legislation and that it actually prohibits unpriced carbon emissions and presents an argument to this court about how it fits in the criminal law power.
Well, how is this not command and control? You're setting certain standards and you're saying this is what we want done. We want it priced on this basis, and this is the way we want to have it done on the behalf of the federal government. That's their position. So how is that not command and control?
Well, there's room for provincial flexibility, as we've already discussed, and it's not a
But for the backstop.
For the backstop, yes. There's the benchmark, and there is the backstop that comes in if the benchmark.
Let me ask you this, though, about, an alternative, though. You say that this is not command and control, but a moment ago, I thought, I heard you say, maybe you better correct me if I wrote my notes down wrong, that the inability theory that you were advancing protects against any province's ability to resile. Canada's cooperative approach did not work.
Yes,
Did you say that?
Canada attempted to do this through, part of the cooperative approach was the agreement that there would be the backstop, because some provinces didn't want to do pricing. They accepted that pricing needed to be applied throughout Canada, but they wanted the federal government to do it. And the territories.
Why doesn't that sound like command and control?
Well, okay, but I don't want to get into the criminal law, the specifics of the criminal law power, because that's the Canadian Public Health argument, not ours.
Well, command and control doesn't just work in criminal law. Command and control works in civil law as well.
Can I return to Justice Wakeling's question?
Well, that's what I was trying to do.
Let me see if I can be of some assistance to get us there. I think that the paragraph that was read to you from Professor Letterman about whether the federal government or the provincial governments would be preferable in terms of dealing with the issue that is before the court goes to the question of provincial inability. And what I was going to ask is whether or not Canada's position is the same position taken by Justice Ledane on how to define provincial inability in paragraph 35 of the Crown-Zellerbach case. Because as I understand what Justice Ledane said at paragraph 35, after a long discussion in paragraph 34, was this: as expressed by Professor Hogg, the provincial inability test would appear to be adopted simply as a reason for finding that a particular matter is one of national concern falling within the peace order and the government power, that provincial failure to deal effectively with the intra-provincial aspects of the matter could have an adverse effect on the extra-provincial interests. In this sense, the provincial inability test is one of the indicia for determining whether a matter has that character of singleness or indivisibility required to bring it within the national concern doctrine. It is because of the interrelatedness of the intra-provincial and extra-provincial aspects of the matter that it requires a single or uniform legislative treatment. The provincial inability test must not, however, go so far as to provide a rationale for the general notion, hitherto rejected in the cases, that there must be a plenary jurisdiction in one order of government or any other to deal with any legislative problem. And so, as I understand what Justice Ledane was saying, that and as a second component of that, the authority is exclusive, but not plenary. Now, that's how I read that paragraph. Tell me whether that's Canada's position, because that's clearly how I read Ledane.
Almost.
Okay.
We do read Ledane that way, but with one important distinction.
All right.
Is that it's not, the provincial inability is speaking to the province that's impacted. So it's like in interprovincial cooperatives, when Manitoba could not legislate to prevent pollution in Ontario, in the Winnipeg River system, and pollution in Saskatchewan flowing into the province of Manitoba in the interprovincial cooperatives. So that's what we're talking about. So it's about the provincial incapacity to address the negative interprovincial impacts. And on the plenary, we agree entirely. And I'll actually take you, the Supreme Court agrees too. In Ontario Hydro, it said exactly that. But the only other distinction I say is that we say that we agree with that is how you read Crown-Zellerbach, that the discussion, the paragraph before wasn't.
It was wrong.
It wasn't Ledane saying this is what Betts said. It was saying this is what Gibson says. Seems to contradict what Betts was thinking. If you go back to what Justice Betts said, Justice Betts actually recognized some role for double aspect, and it was in regard to water tank compartments era decisions. But in any event, it was really just we don't think. I think this seemed like what Gibson says and what Justice Betts said don't seem to match up together. But this is important to know. Professor Gibson published his paper at the same time that the decision from the Supreme Court of Canada came out. So Justice Betts did not have the opportunity to consider Professor Gibson's paper. It was after that, and perhaps this is best to do after the break, is the history of the provincial inability test and how it then got brought into both the national concern doctrine and the trade and commerce doctrine. Because the thing that I'm going to say is the only thing we say that is different from what Dan said here in paragraph 35 is that we think with the evolution of the use of the provincial inability test in trade and commerce, in securities reference and in pan-Canadian securities reference, that it's more than just an indicia. It is almost a determining factor as to whether or not there is a distinction, a dividing line between provincial and federal jurisdiction. Because if there is provincial incapacity, then it's not within provincial jurisdiction.
Just so you know before the break, I think that in the last two sentences of paragraph 34, which is where you're now at, where Justice Ledane says, here's what Justice Betts said, he's wrong. What he says is that there is a conflict that was emphasized by Justice Lebetts in the anti-inflation reference, where that matter falls within the national concern doctrine of peace, order, and good government, as distinct from the emergency doctrine. Parliament has an exclusive jurisdiction of a plenary nature to legislate in relation to that matter, including its intra-provincial aspects. And last night I went back and reread Betts because I did not find that anywhere in Betts. This morning I actually asked for a word find in Betts to see whether Betts had ever said that exclusive jurisdiction was plenary, and the word plenary never appears. So I think that I can start off with a proposition that those last two sentences in paragraph 34 in Crown-Zellerbach are simply wrong. Justice Ledane got it wrong. And that's why he's enabled to go into paragraph 35 and correct himself when he says, to provide a rationale for the general notion hitherto rejected in the cases that there must be a plenary jurisdiction in one order of government is wrong.
I would concur with that reading, and honestly, so would the Supreme Court of Canada, I guess just before the break.
I think Ontario Hydro said the same thing, didn't
Ontario
it?
Hydro says exactly the
That's
same.
how I read that as well.
So that's at tab 41 of the condensed book. And
So just so we're all clear then, because I was going to ask you that, and I think it's going to be a good time to take a break momentarily, was whether you agree that the Parliament would then have exclusive jurisdiction over
minimum
this
national
issue.
standards integral to reducing greenhouse.
Pardon me?
Exclusive jurisdiction over minimum national standards integral to reducing.
Have exclusive jurisdiction over minimum national standards, which means essentially whatever you want to make of that. Minimum national standards could be everything because you set the minimum national standards, so you in theory could cover the waterfront with the minimum national standards. But let's leave that aside. You're saying they would have exclusive jurisdiction. Now we're parsing words to whether or not Justice Ledane had it right or wrong when he wrote paragraph 34 in Crown-Zellerbeck. So the words were, he referred to what Bates said, and then he said, where it falls within the national concern doctrine, et cetera, Parliament has an exclusive jurisdiction of a plenary nature to legislate in relation to that matter.
And that word never, ever appears in Justice Betts'.
Well, that's a different issue. That's his interpretation of what was said by Justice Betts. So could we then, I want to just follow up further on that and not debate with my colleague on what the meaning is of what Justice Bates said. We'll have time for that later. The fact is, I just wanted you to then take us, because you mentioned that you think that this was further clarified in Hydro-Quebec, so that
Ontario Hydro.
In Ontario Hydro. So if you could take us to that, that would be very helpful.
I will take you to tab 41.
All right, thank you.
And there are, so this decision broke down 331. And Chief Justice Lemaire wrote for himself, and he ultimately agreed. He agreed with the majority, which included Laforêt, which found that labor relations were integral to Parliament's jurisdiction over atomic energy. But on this point, Lemaire agreed with Iacobucci, a point on which Laforêt never disputed.
Okay.
And the point is, at paragraph 2, there's two, I'll take you what Justice Lemaire said, and I'll take you what Justice Iacobucci said. Justice Lemaire said, I agree with Iacobucci that Parliament's legislative authority starts out with over works, but then over works such as nuclear generating power, whether it arises pursuant to its declaratory power or constitutional scheme is based. Under section 9210C, I fully agree with Iacobucci that Parliament's declaration over a declared work must be limited so as to respect the powers of the provincial legislatures, but consistent with the appropriate recognition of the federal interests involved. The POG power is similarly subject to the balancing federal principles, limiting the federal government's POG jurisdiction to the national concern aspects of atomic energy, namely the fact of nuclear production and its safety. And then if we go to what Justice Iacobucci said, and we see this at page, it's the last page in the tab, and it is the bottom of paragraph 181, after Justice Iacobucci sets out the national concern the 4 tests from Crown-Zellerbeck. And he says, with regard to the last factor, the provincial inability test, Justice Ledane hastened to caution that the test must not, however, go so far as to provide a rationale, and this is the quote that Justice Fian just read. Therefore, the federal government may have jurisdiction over atomic energy by reason of the national concern branch of POG. that the federal government may have jurisdiction over atomic energy by reason of the national concern branch of the POG power does not give Parliament plenary power over all aspects of nuclear power. And go on. The POG power, like all of Parliament's power, must be interpreted in accordance with the specific grants of powers to the provinces under Section 92 and 92A. While there is no dispute that Parliament has jurisdiction over atomic energy under the national concern branch of the POG power, the extent of what is swept within Parliament's jurisdiction is circumscribed to the national concern aspects of atomic energy. And here we are saying the same thing, that this court, in defining that power, needs to circumscribe it to the national concern aspects, which is what Canada has been attempting to do throughout, because we say the legislation is directed at those national concern aspects.
So does that mean that just because there's a federal dimension, which is the national concern dimension, that doesn't end the inquiry? We still have to ask the next question.
And the third question.
And that is,
It's a three-part test.
well,
Yeah.
I'm already giving you the national concern doctrine. And then I'm using the Letterman analysis. So we'll give you national dimension doctrine that triggers federal dimension. And then we have to ask which interest is most important. And we're entitled to ask that, and even though you've got a national concern doctrine on your side.
And we say the answer is the federal interest is most important because it is beyond the capacity of provinces to deal with the matter as it is defined. So for this legislation and the matter to which it's related, the federal aspects of it predominate. They are more important.
Does it matter if all of the big players, all of the big provinces are prepared to do what you think is, what the government of Canada thinks is needed to be done? There's only a couple of stragglers. Do we have to look, can we look at that and see how that's going to work out? So you've got Ontario, Quebec, Alberta, Saskatchewan, BC saying, yeah, we want to do this. And the Maritimes say, no, we don't want to. It can be done without everybody playing the game.
Well, we say the evidence is still that it cannot be done because there are the interprovincial impacts, and there was evidence before Parliament of that.
No, I haven't looked at the data out of Nova Scotia, PEI, New Brunswick.
They don't produce a lot of emissions. They do not produce a lot of emissions.
Kind of thought that.
They are
Why could we?
significantly impacted by climate change.
They don't have a lot of emissions, but people in, the real issue here, I think, comes back to the point I had asked about earlier, and I think that sometimes we appear to drift away from that in looking at this issue as well, is that we never quite get to the point of what is the relationship here, what is really in dispute here. We have an environmental issue on one hand, and we have an issue of control over natural resources and economic development on the other. And the question is, how do you balance that? And who is best suited to balance that in terms of controlling greenhouse emissions and not destroying a province's economy? So that's the conflict. Economic development on the one side versus concern for the environment and stepping past the province on the other.
I would take really a big issue with you putting economic development on one side and taking steps to reduce greenhouse gas emissions on the other side.
And why?
Evidence before this court,
Yes.
or Parliament, was that the implementation of the carbon price throughout Canada was going to have, that's again at the same tab in the estimated impacts document, and this is all described in detail as to how it was developed. If you look at tab 22, R800. So this is the evidence that was before Parliament. It shows the range of forecasts for GDP based on models. It shows the projected GDP with carbon pricing and the projected GDP without carbon pricing. And the differential is incredibly small and within the normal range of, it was 0.1% of GDP difference with carbon pricing.
And that was with carbon pricing at current levels or with carbon pricing at the levels that they could be at if they changed tomorrow?
That was with the carbon pricing as the act was before Parliament, and so the current levels increasing to $50 a ton. We know from BC, the evidence that is in the record is that the carbon pricing in BC, their economy has done incredibly well with carbon pricing. We know that Alberta has had carbon pricing since 2008, and until the recent drop in oil and gas prices, Alberta's economy has done very well. And this economic forecast specifically doesn't even take into account the innovation that may come as a result of carbon pricing and getting out ahead in the transition to the new economy.
Well, you're absolutely right on that.
I would not say that they're juxtaposed, it's either or.
Well, you've got the 92A, perhaps I shouldn't have said economic development, management and control of natural resources on the one hand, and who controls that versus the impact of the carbon pricing on the other. That's part of what you're hearing is the argument of the provinces is that this is interfering with their control over management and development of natural resources. So that's one of the arguments. And to follow up on that before we break, because I want to come back to this, you took us to Professor Savage's comments about pricing, and we got sidetracked from what we were discussing earlier. But one of the issues that he talks about is the importance of pricing carbon to maintain as well international competitiveness. And I would just like you to explain to us how the international aspects of competitiveness on pricing of carbon are being dealt with. In other words, the competition on pricing of carbon for certain industries is not really interprovincial, it's international. In other words, they're not producing oil and gas in large quantities in, let's say, Prince Edward Island. But they're producing oil and gas in large quantities in, let's say, Alberta and Saskatchewan. So my question here is, how does that carbon pricing take into account the carbon leakage internationally and the necessity of providing and ensuring a relative competitive position for the oil and gas industry in Canada versus what the prime competition might be for that, say, for example, the United States?
So and the short answer to that is through the adjustment of the output-based standards. For Alberta and Saskatchewan, though, you need to understand that the federal industrial pricing system does not apply to the oil, either Saskatchewan or Alberta.
That's because
each of the provinces, and Alberta priced the industrial emissions going back to 2008. That's what Mr. Savage was saying. So they adjust the output-based standards that apply to their industry to account for competitiveness impacts.
I understand that, but the question is, how does it apply going forward? Not today. I understand that Alberta has agreed to a certain pricing regime and the federal government has, quote, approved that for plants in Alberta. What I'm asking about is how that works in the future and what assurance there is that the competitive position of the oil and gas sector in Canada, which is largely in Alberta and Saskatchewan and some in BC, will be maintained vis-a-vis international competition. Where is the assurance that that will happen?
Well, that was certainly part of the purpose of having two separate sections to the Act as integrated. As an integrated whole. So part one of the Act, part one of the Act applies the fuel price to the fuel charge to fuel producers and distributors. It's not actually a direct charge at the pumps. Mm-hmm. It's anticipated that it gets passed through.
Just anticipated to be passed on through, right. Which last time, as I understand, it is.
Yes. Part two is a big carve out of that. Mm-hmm. Either the industrial-based pricing system or Alberta's tier or, the CCIR, if it had continued, if Alberta's CCIR had continued, it would have been a big carve-out too. There's an ability to integrate part one and part two. So facilities that are subject to either the federal output-based pricing system or the provincial output-based pricing system are not subject to the fuel charge. That is one of the ways competitiveness impacts were addressed, because you'll see in the regulatory impact analysis, which is at tab 3, and I'm not going to read it to you, but I commend it to you. It shows an analysis of the different impact that would have occurred if a straight fuel charge had been applied versus an output-based pricing system. The output-based pricing system is already a system designed to address the competitiveness and international carbon leakage impacts of the output-based pricing system. And that is explained, how those were established in the federal system is explained in Mr. Moffat's affidavit at paragraphs 133 and 34, and then 148, 49, and in Exhibit SS, which is the RIAS. And the standards were set using a 3-part test. That's right, to achieve the additional objective, and this is an additional objective. This is at tab 7, page R48. The additional objective of Part 2 was to minimize competitiveness impacts and the risk of carbon leakage for industries engaged in trade. ECCC used a 3-phased approach to assess potential competitiveness risks from the output-based pricing system. He then explains that 3-phase approach in detail as to how they developed those different standards. So the 80%, the 90%, and the 95% that you saw in Ms. DeMarco's presentation this morning. And those were adjusted based on the international trade impacts, potential international trade impacts of the federal system, which is a valid federal purpose, taking into account international trade impacts. And so, for instance, cement, we know it's an emissions-intensive trade-exposed industry. Its output-based pricing system was set at 90. I note that Ontario, under its former CCIR, had the output-based standard for cement actually set at 100%, because cement is particularly trade-exposed in the evidence. And so the limit on the cement industry is, yeah, there's a little bit of a downward pressure, but we can't put too much without destroying the cement industry in an international trade perspective. So that is how that gets balanced, and that is why there's the flexibility in the regulatory framework.
That's all well and good, but the question I'm getting at is who makes the call on any of this under this legislative regime? So, for example, going forward, we know what the numbers are for till 2022. Beyond that, I take it that you would agree that it's fully within the discretion of the federal government to decide how little or how much, or if at all, they will take into account competitive pressures from other countries.
Well, I mean, yes, but yes, but I mean, and that but is a really big, important but, because the federal government also has to be very cognizant of the economy of the country as a whole. It can't, I mean, it could. It could.
So the federal government's sense of social responsibility.
Prohibit all exports of bitumen and you know, let's be reasonable about what Parliament does in exercising its jurisdiction and how it takes into account the whole range of factors.
I'm just going to, before we break, you left us at on Ontario Hydro. If we go to tab 37 in your condensed book, which is Regina and Hydro Quebec at paragraph 67.
Yes.
It contradicts what was said in Ontario Hydro.
You're right. So in the dissent in Hydro Quebec, the dissent picked up on that statement out of Crown Zellerbach that Justice Ian has done a very good job of explaining why it was a mistake and why Justice Ledane went on and then clarified. And unfortunately, that dissent, pulling out what Ledane said, attributing it to Ledane, not to being Ledane's interpretation of what Betts said, and saying it was a finding of Ledane has sowed some confusion. But I guess that leads to actually.
Can I leave one last? Can I leave one last thought with you on the way out the door? And that is when you're referring to our door, when you're referring to importance, even under Lederman's test, the importance is the impact on the legislative authority of the jurisdiction affected. It's not the importance on the facts. A snapshot of the facts on a given day by any particular expert witness about how much money would be this or how much. That's one view. I'm not. That's your view. That's the view that's been advanced. You're saying that we look at the dollars and cents and how many people are this and that and so on. I'm suggesting to you that the importance is referring to the impact on the jurisdiction, the legal jurisdiction. That's where the importance fits in. So the impact on 92A is big. The impact on the federal jurisdiction is tiny. And so if, on the standard that my colleague, now I'm not speaking for my colleague on this respect, because let's say Justice Wakeling, he may disagree with me on that. But I think that's at least one good argument as to what happens. You don't have to debate it with me. I'm just out the door.
You guys ultimately get the last word.
Well, exactly.
We'll let you have the
Importance
last
of the
word.
national versus provincial dimensions of the problem.
Yeah.
I think that goes back to also bringing in Professor Gibson's analysis.
I understand. I appreciate that. Yeah.
Take a break.
All right, we'll take a break then for the afternoon. And thank you so much, Council, for answering those questions so well and for your submissions. Thank you.
Order in court.
So I'm in the court's hands a little bit. The clerk has advised me that I have 13 minutes left of my designated time. Obviously, the bench has been fairly active with questions. I was hoping to reserve some time for my colleague, Ms. Moore, to actually address the characterization of charge and taxation issues. I know I still have, Chief Justice, your question to answer about provincial inability. You wanted a bit more of a description of the history of provincial inability, a question, some minor suspicions on exclusivity, the question about 92A, and I have a brief comment to make about greenhouse gas emissions. I think I have, subject to how much interaction there is, another 45 minutes, if the court would indulge me with a little extra time.
45.
Well, we've asked you a lot of questions, and if you could just do your best, I know you want your colleague to be able to have some time as well. And so I would just suggest that you carry on then.
I will certainly try to be as pointed as possible. Of course, at the same time, responsive to questions. Moving on to, I mean, we've had a lot of discussion about the definition of the matter and the characterization of the Act. You know what Canada's position is on what we say is the dominant essential character of the Act. We've spoken about why we say that meets the first test of Crown Zellerberg, why there's been a constitutional transformation. The next step in the Crown Zellerberg Act is whether or not it's a single, distinct, and indivisible. Really is a distinctiveness. We think that's a compendium construct when Justice Betts described it in anti-inflation reference. And the matter as a whole in its description is described, we say, in a way that is distinct from provincial jurisdiction, which is really the important question. We also say, though, although it's narrower than just greenhouse gas emissions, that the inclusion of greenhouse gas emissions in itself is part of why it is it's distinct from versus the environment or pollution as a whole, which is what some of my friends were saying in their submissions yesterday. Greenhouse gas emissions are precisely defined, as we know, Justice Fian pointed out yesterday. They're equated to each other based on a carbon dioxide equivalent. They're defined by the United Nations. They are a known, persistent, pervasive, interprovincial pollutant, and they're defined that way by the United Nations. And so they are a very distinct subset of pollutants. And I'm going to rely largely on what I say in the factum on this point. I do have two quick points. First of all, in Hydro-Quebec, which this court is clearly familiar with, the reason of the dissent there for not upholding on the national concern doctrine is that the definition of toxic substances was so broad that it included substances that were entirely harmless and intra-provincial. And it did say in that decision that if it was limited to toxic substances that did have an extra-provincial and deleterious impact, then they may have actually upheld it under the national concern doctrine. So we see that case as actually supporting the national concern doctrine here. We do also see the minority in Crown Zellerberg, Justice Laforet's comments, also supporting recognizing national concern here. And I would commend to you, I won't take you there, but I would commend to this court paragraphs 44, 45, and 55 to 60 of Justice Laforet's dissent in Crown Zellerberg. 44 and 45 are to contextualize how Justice Laforet saw the pith of that act. He saw it as applying to dumping specifically in the province of a non-noxious substance with no evidence of any movement of that substance. And when you read then and in that case, he saw that there wasn't the national dimensions shown. But when you read what he says at paragraph 55 to 60, we say that his analysis there would uphold recognizing the national dimensions of greenhouse gas emissions, which we say is captured in minimum national standards integral to reducing greenhouse gas emissions. Just before I leave this point, I would also like to note that Crown Zellerback, well, make one correction to the submissions by Saskpower this morning. They indicated that Crown Zellerback involved the general power, property and civil rights. But in fact, Crown Zellerback involved section 92.5 provincial jurisdiction, which was the management and sale of the public lands belonging to the province, and then timber and wood thereon. A previous decision had found that the lands, or the ocean bed belonged to the province. So this was about the province's ability to manage provincial lands. It's a much more specific than just property and civil rights. Moving on to provincial inability, we've had a lot of discussion about it already, but I do wish to take this court through the evolution of the provincial inability test somewhat, because we still need to understand that it very much is getting at the interprovincial impacts of a province's decision to not, a province's resiling from doing something about the problem, and the incapacity of the affected province to do anything about it. And so tab 35 is the Crown Zellerback decision, and Justice Ledane reviewed the history of the national concern doctrine quite extensively. So we know that Professor Gibson first identified provincial inability as a unifying thesis, as a way to explain the national concern decisions that had come to date. And Professor Gibson's discussion of that is at tab 38 of the condensed book. And of course, that was the same time when the Supreme Court decided anti-inflation reference. So Justice Betts did not have the benefit of Professor Gibson's thinking. But after that, the Supreme Court then conceptually adopted the provincial inability test into both the test for the matter of national concern and concurrently into the test for the general trade and commerce power. So although the two powers are different, we know that they do share some important similarities, including the need to find the limits to protect provincial jurisdiction. And so this is why we say that the Supreme Court's jurisprudence with respect to provincial inability in trade and commerce, particularly as it was developed through Canadian National Transportation, GM, which is where the provincial inability indicia moved into the majority of the Supreme Court, and then in securities reference and pan-Canadian securities reference. And in fact, my friend from Ontario also seems to be suggesting the same thing in arguing that it needs to be the federal matter needs to be qualitatively different from a provincial matter. That is being drawn from the trade and commerce securities and pan-Canadian securities decisions as well. So if we look at Crown Zellerback, starting at paragraphs 30 to 32 of that decision, Justice Ledane does a beautiful job of tracing the history. The provincial inability test was first mentioned in a Supreme Court of Canada decision in 1980 in the Labatt's Brewery case, in which a majority of the court found that certain provisions of the Food and Drug Act were ultra vires. They considered, including Justice Betts, I note, considered the peace order and good government power as the basis of validity. And Justice Betts, you see, noted that there is three heads of it. And then at the very last part of that paragraph, Justice Estes saw the national concern doctrine enunciated in the Canada Temperance Federation as covering the case not of a new subject matter, so this is the national concern doctrine, not of a new subject matter which did not exist at Confederation, but the one that may have begun as a matter of a local or provincial concern, but had become one of national concern. And then you see at the end of that paragraph, in Labatt's Brewery, they quote Professor Hogg, who had commented on Justice Ledane, to say that the most important element of national dimension or national concern is the need for one national law which cannot realistically be satisfied by cooperative provincial action because the failure of one province to cooperate would carry with it grave consequences for the residents of the other provinces. Now, in Schneider, it's next mentioned again in Schneider in 1982, and this was the Heroin Treatment Act case I referred to briefly before. In prior to Schneider, the Supreme Court had found that upheld the Narcotics Control Act under peace order and good government. It was at a time when they weren't sure if criminal law would cover narcotics control. So it was upheld under the peace order and good government clause at that time because they saw interprovincial negative impacts of narcotics.
I thought there was argument in the court. I thought it was a suggestion that there was arguing in the court itself, and so the court itself went this way to avoid having to deal with it.
Yes. Yeah, the court at that time was divided on.
Yes, yeah.
So, but then that led to the Schneider case where the court unanimously upheld British Columbia's Heroin Treatment Act as being intra vires the province. And again, you see Justice Betts concurred there, indicate that with particular reference to the national concern doctrine and what had become known as the provincial inability test, why he was of the view that the treatment of heroin dependency as distinct from the traffic in narcotics was not a matter falling within the peace order and good government power. And here you see in the middle paragraph that's quoted out of Schneider that they reference Gibson, Professor Gibson's theory that it has to be beyond a provincial power. And then you see at the very bottom, it's not sidebarred, but the last paragraph, in the middle paragraph, it says, failure by one province to provide treatment facilities will not endanger the interests of another province. So this was the point I was making in relation to the lawnmower regulation. And then at the end, I do not see the subject of narcotics as so global and indivisible that the legislative domain cannot be divided, illegal trade in narcotics coming within the jurisdiction of the Parliament of Canada, and treatment of addictions under provincial jurisdiction. There was a lot of development in the national concern doctrine, or a lot of activity at that time. 1983, a year later, we have in Wetmore debate about, again, the Federal Food and Drug Act, and they considered criminal law power or peace order and good government power. And I think the point I want to note is over on the next page there, the sidebarred bit, which would be on page 31 of the official reports, where the Supreme Court there reviewed what had come to date and said these cases suggest, or they quoted what Estes said in Labatt's, that the most important element is the national concern dimension, which is that it can't be realistically satisfied by cooperative provincial action because the failure of one province would carry grave consequences for the residents of another province. And that then led into Justice Ledane developing what he said is the four the 4 points, but the first point is really just making the point that there is a distinct national concern doctrine that is separate from the national emergency doctrine, and then sets out the three tests that, now he sets it out as the first test being the need for for there to be a national concern, that need for the transformation that we've talked about. He actually puts the single, distinct, and indivisibility, the distinctiveness test, and the reconcilable scale of impact test under point 3. We say those are actually two separate tests. And then refers to provincial inability as an indicia of it being single, distinct, and indivisible. And we had that conversation before the break, that we say it is in fact more than just an indicia. It really is one of the most important characterizations for this for this step in the 3-part test. And then this court knows, is familiar with the securities reference cases and the Pan-Canadian securities reference cases. We know that what are now indicia 4 and 5 of the trade and commerce power were adopted into the trade and commerce power in that same era by Justice Dixon, first in dissent in Canadian National Transportation, and then in the majority in GM leasing, which is the test that remains today. And the Supreme Court recently considered the provincial inability test in the trade and commerce power in Pan-Canadian securities reference. And what they said at paragraph 113 to 115 really captures the way the test operates, and that's at tab 39. And here it speaks about the fourth indicium, that we have the view that provinces acting alone or in concert would be incapable of enacting a scheme like the draft federal legislation. And they reference back to the Securities Act reference, saying the provinces acting in concert lack the constitutional capacity to sustain a viable national scheme aimed at national goals such as the management of systemic risk or a Canada-wide data collection, given that each of the provinces retains the ability to resile from an interprovincial scheme. And this is the fact that one parliament cannot bind the next parliament, or one legislature cannot bind the next legislature. So although it may be that there could be a scheme, a national scheme could be achieved, the national aspects of the problem could be achieved by all of the provinces cooperatively agreeing to addressing it to whatever is necessary to meet meet the national aspect of the test. That is not the question. It's not that could it be achieved if all of the provinces did something, because the question is whether there needs to be protection against provinces' ability to resile. And that comes down to that comes down to then the impacts when a province does resile. So it's the fact that one province can opt against participating in or subsequently resile from a cooperative scheme would seriously impair that scheme's capacity to protect the Canadian economy from systemic risk. And it's important that you see at paragraph 114, we accept that provinces can and do regulate systemic risk in their capital markets. However, our federal jurisprudence supports the principle that a subject matter can both have a federal and provincial aspect. It cites a number of cases there. In such a case, the double aspect permits the provinces to legislate in pursuit of a valid provincial objective and Parliament to do the same in pursuit of a specific federal objective. While provinces have the capacity to legislate in respect of systemic risk in their own provinces, they do so from a local perspective, and therefore in a manner that cannot effectively address national concerns which transcend their own respective concerns. It makes, and then on the fish, and then 115 is talking about the fifth indicium, which is that one jurisdiction's failure to participate would jeopardize the scheme's successful operation. And this is why the evidence that's before this court about the interjurisdictional competitiveness impacts and carbon leakage impacts that were noted by the Saskatchewan Court of Appeal and the Ontario Court of Appeal. The Ontario Court of Appeal, in fact, the majority found that there were interprovincial negative impacts if this particular measure, carbon pricing, did not apply throughout Canada. And that's what we say is captured in the matter when we say nationwide GHG emissions, that just as the trade and commerce power requires that, has the fourth and fifth, the provincial inability test as an indicium as to whether or not it comes into the trade and commerce power, we are saying that this matter, the minimum national standards integral to reducing nationwide GHG emissions, has embedded in it that same provincial inability test. In other words, so it can't just be minimum national standards for anything. There has to be evidence before the court that if there wasn't some uniformity in legislation across the country, that there would be negative interprovincial impacts as a result of the lack of uniformity, the ability of a province to resile from a cooperative scheme, and that the successful non-participation would jeopardize the successful operation of the scheme. We were discussing the concept of exclusivity just before the break, and actually I think we covered a fair bit of it. Let me just, if I have a moment, to look at my notes and see if there's... Okay, so, well, I would note, following up on what Justice Fian said about reading the anti-inflation reference over again to find out if what Ledin said, Justice Betts said, was actually there.
Well, can we all, in that regard, then, I'm sorry, but I'm going to have to take everybody to page 40 of that judgment on the anti-inflation case, because I think that what you have is an interpretation later by Justice Ledin of what Justice Bates said in dissent. And on page 40, he has a paragraph there, which is at tab 17 of volume 2 of the Crown of Alberta's documents. He said, if you start looking at it, partway through that, I guess, what is the second last paragraph, starting with the word "I disagree." So that's volume 2 of 4, and it's at tab 17. And what we're looking for is, what is he talking about here in context of exclusive jurisdiction of a plenary nature, and why did Justice Ledin in the later case refer to this as if Justice Bates had said something to that effect in the earlier case? And Justice Bates may not have used those exact words, but I suggest that potentially what I'm about to read to you is in effect what he was saying. And that is starting with the paragraph, "I disagree with the proposition that the national concern or national dimension doctrine and the emergency doctrine amount to the same." And he goes on a little later to say, "The national concern doctrine illustrated by these cases applies in practice as if certain heads, such as aeronautics or the development and conservation of the national capital, were added to the categories of subject matters enumerated in Section 91 of the Constitution when it is found by the court that in substance, a class of subjects not enumerated in either section 91 or 92 lies outside the first 15 heads enumerated in section 92 and is not of a merely local or private nature. And where the national concern theory is applied, the effect is permanent, although it is limited by the identity of the subject newly recognized to be of national dimensions. And so I take from that what he is saying is that it falls within the category under section 91 of the, or 92, when it's outside of those, it's as if it were included within it. So what do we make of that then? I mean, does that then you suggest mean that that there's a double aspect to the legislation if something touches on it at other level of government?
Well, so what we say is that that the meaning of exclusivity is no different for a POG matter of national concern than it is for any other exclusive head of power. That exclusivity has exactly the same meaning, which means that in this case, with respect to greenhouse gas emissions, there is absolutely double aspects. There's multiple aspects, as we have seen. The province couldn't purport to regulate directly in relation to a federal head of power or in relation to the matter of national concern. The matter of national concern, establishing minimum national standards integral to reducing greenhouse gas emissions, a province, that would be outside of a province's jurisdiction to do. A province could try to establish minimum national standards. They just simply couldn't do it. So to that extent, a province can't legislate in relation to that matter. But a province can legislate in relation to property and civil rights, in relation to education, in relation to health, in relation to 92A, and in any of those legislations, legislating in relation to, it can bring in measures to address greenhouse gas emissions in relation to those powers in the province. And that's where the double aspect comes in, is that there are provincial aspects to regulating greenhouse gas emissions, as we see by BC's legislation, direct taxation in the province, as we see by Quebec's cap and trade, industrial relations within the province, as we see by Alberta's tier. There is no conflict between the legislation and those acts. They remain valid. There is no conflict. Those acts all remain valid if this court recognizes minimum national standards integral to reducing greenhouse gas emissions as a matter of national concern. None of those acts are enacted in relation to that matter. So it's the same as every other constitutional analysis of exclusivity. That's what we're saying about double aspect. And the legislation can be practically identical. Multiple aspect, the multiple access case, for example, and I won't take you there. It's in our book, condensed book, but it involved federal legislation that created a civil. Maybe I need to pull it up. It was a federal Companies Act section that was challenged that had a provision that was almost identical to provincial Companies Act legislation in Ontario, and it was challenged. And they were verbatim almost the same, except that the provincial legislation was directed towards companies enacted under the provincial legislation, and the federal provision was directed towards companies enacted under the Federal Companies Act. And that's important because that federal companies, the ability to incorporate national companies was recognized under peace, order, and good government, I believe as a gap, but it's a peace, order, and good government power. Subject to any questions about double aspect. I'll move on to the question about the confusion about.
By the way, on double aspect, you're not suggesting interjurisdictional immunity, are you?
Not on double
Right.
aspect, but in relation to the submissions that AIDA made this morning, and in relation to the submissions that Saskpower made this morning, we say that the.
And the reason you say this is a double aspect, though, is because the one aspect is national concern, the other aspect is the matters which are coming within the classes of subjects by this act assigned exclusively to the legislatures.
Yes.
In other words, you erased the clause from after the word Canada and up to the for greater certainty out of the Constitution. You've taken that out in your approach, right? Because it says in relation to this general power is residual. And it says, for peace, order, and good government in relation to all matters not coming within the classes of subjects by this act assigned exclusively to the legislatures of the provinces. And you're saying, based on the case law analysis you've put forward, so it's not like it's no provenance of what you're talking about, but you're saying that that no longer matters as long as it relates to a matter of national concern, then it can relate to a matter coming within the classes of subjects given to the provinces.
I'm not saying the words of the Constitution don't matter. I'm saying the words of the Constitution support the existence of the national concern doctrine when there has been a constitutional.
No, but you're saying the national concern doctrine, we've covered this already, so I don't need to cover it again. But you're saying the national concern doctrine actually overrides. Well,
It doesn't override.
it occupies the same space.
We're saying that because of the national aspects of the problem, there is, one, the evidence demonstrates that there's the national dimensions. That's the first hurdle. Two, there is a matter that is distinct from matters that provinces can address because of the provincial inability test. And that because of the provincial inability test, it doesn't come within the matters assigned exclusively to the province because Section 92, all of the powers are in the province, of the province. And no province can address another province, the impacts on it of another province's resiling from a scheme that has that results in negative interprovincial impacts if it's not applied nationally. So we're saying it's not overriding. It is no longer a matter that is within the matters assigned to the legislature.
What you're saying is you've got to
from the national dimension aspect of it.
You're saying that because you've got something that one individual province could not address, which is a national issue of national concern, that does not fall within one of the enumerated grounds, as I understand it.
Because of the national dimensions of the problem, yes.
And because of the constitutional transformation criteria.
Yes.
But you don't go so far as to say that there's concurrent jurisdiction.
No. We're not saying concurrent jurisdiction. We're concurrent operation of federal jurisdiction and provincial jurisdiction and the federal jurisdiction is directed towards the federal aspect and provincial jurisdiction is directed towards the provincial aspects of the problem.
Hence the double aspect.
Hence the double aspect.
So really, the sticking point here, the point of departure between you and your friends is the question of the addition of the words national standards of greenhouse gas emissions. So they say greenhouse gas emissions are within our purview exclusively for the provinces. You say, look, that may be true, but it's got a national dimension, and you want to add the words national standards to that. So once you want to aggregate, as it were, the powers of the various provinces and say, look, there's a larger issue here that includes all of the provinces, and that's what makes it a matter of national concern under your interpretation of the national concern doctrine.
We're not saying we're aggregating the provincial powers. We're saying we're addressing an aspect that provinces do not have the capacity to.
Well, they're the ones who have the individual powers. You're saying the new issue or the transformative one is that you want to take their combined provincial authority and impose, as it were, national standards that all of them have to meet. So you're saying this identified need for national standards takes their individual authority, as it were, and makes that less important, to use the phraseology of what's more important. What becomes more important is the national standards. What it comes back to is how you characterize what this is and what this is directed to. Is this control of greenhouse gas emissions? Or is it, as you say, a separate category of national standards for greenhouse gas emissions, which takes us directly into, I think you should wrap up with the last part of the test, which is the effect on the provincial jurisdiction, because that's where the other sticking point is, where I think the federal government and the provincial governments are most in conflict with one another, because they say this is a direct intrusion into substantially and potentially every aspect of anything that we can control. Because if you can impose national standards for this, you can impose national standards for anything. So they look at the individual case and then they expand that to other potential intrusions into provincial jurisdiction, which means that that third part of the test is the one that we really need to zero in on.
Right. Well, so then that is the reconcilable concern aspect. And their arguments really fall into two. There's the one which is about displacement of provincial powers because of their interpretation of exclusivity and saying that there's no role for the federal aspect. I think we've moved past that. The other is the sort of federal overreach argument that, well, if you can do this, you can do everything. And I say that the definition of the matter, which we say incorporates the provincial inability test, the rigor of that test, the need to operate on an evidentiary basis, and the judiciary, which acts as the impartial arbiter of where those lines are drawn, all protect against federal overreach, particularly the pith and substance analysis. So we've been through that. You know our position that it's not in relation to the provincial powers, that it is in relation to this hog power. Now, that brings up the question of impact, and that's really where, if the legislation following the pith and substance analysis is in relation to this new federal matter, this matter of national concern, future legislation is being tested. Does it fall into this matter of national concern? Well, the first thing there's going to be is that pith and substance analysis. So the rigor of the definition of the matter and the need for Parliament to have acted on an evidentiary basis and the need to demonstrate provincial inability. That in itself is a significant test. Is it in pith and substance related to that matter, which, like the general trade and commerce power, it is, as we know from the First Securities Act reference, it's a challenge to meet that test. It's a rigorous test.
I know, I don't want to interrupt, but I'm sort of sensitive to the fact that your friend needs some time as well to make her submissions, and it is now it's 4:22, and my concern is we have actually spent quite a bit of time talking about the matter. I really think it's important for you to be able to address the issue of the scale of impact on provincial jurisdiction.
I will do that right now. And the answer to that question is the Canadian Western Bank case. So this is, you asked if there was any authority for the idea that in the future you can argue about, well, the scale is now too deep, it's sterilizing our ability to use this power. Well, that is the interjurisdictional immunity doctrine. And it's very well described in the Canadian Western Bank case. One legislature's exercise of its power can affect another legislature's power as long as the legislation is not in pith and substance related to that. So the act was not enacted in relation to controlling, in relation to 92A, so we say. I mean, ultimately you will have the say on the characterization of the act. If the act is not characterized as being in relation to that provincial head of power, if it is characterized as being in relation to the hog power, then it can affect, just as criminal law power, just as the fisheries power I referred to earlier, it can certainly affect provincial powers.
No, but in order to characterize it as a national concern, you first have to meet the test. You can't say, well, because it's a national concern, it follows we can affect the powers under the provincial jurisdiction. You have to first meet the national concern test. And to meet the national concern test and to have it characterized as a matter of national concern, we're invited by the Supreme Court of Canada to decide, but first of all, whether this has a singleness, distinctiveness, and indivisibility that clearly distinguishes it from a matter of provincial jurisdiction. And you say that is the case because even though greenhouse gas emissions fall within the province's jurisdiction, they can't set national standards. They cannot deal with anything beyond their boundaries. So you've addressed that very well. But it also goes on and says, and a scale of impact on provincial jurisdiction that is reconcilable with the fundamental distribution of powers under the Constitution. So the question is, how is that aspect of the test satisfied here such that we should conclude that it is met and this is therefore a matter of national concern?
And that is what I was trying to address, is that there certainly the concept of there is a concept of interjurisdictional immunity which could apply to protect the core, potentially. Now, we know the Supreme Court is maybe moving away from that. But we say that the pith and substance analysis in future affects that. This legislation, the evidence before the court, you have to look at the evidence before the court. And the evidence before the court is that it isn't going to have that significant of an impact. And that's really what we can rely on. Now you're looking at what is the impact of recognizing this matter in the future. Well, what we say is that it's the pith and substance analysis, the rigor of the test, the definition of the matter are the things that limit its scope. And because the scope is limited, that will have a reconcilable scale of impact.
So drawing the Canadian Western Bank into the picture is a question of saying, in order to have any relevant scale of impact on provincial jurisdiction, the federal law has to attack the core of the provincial power concerned. Otherwise, it's irrelevant, and national concern is met, and away we go.
Well,
is that what you're saying? Is that what you're saying?
That was how the Saskatchewan Court of Appeal ended up characterizing SaskPower's arguments. They felt that it was more about an applicability argument, not a validity argument.
Yeah, then of course they tried to explain it and missed that. Yeah.
But
I'm right there.
This court is understanding it differently.
Is this actually what you are arguing, that in order to be an improper intrusion for purposes of national concern onto provincial jurisdiction, it has to go to the core aspect of the province's jurisdiction?
That is not what we are arguing.
Well, then what's relevance is there to the test on interjurisdictional immunity, which depends on the core? How does it help?
When we were, until this exchange, we were understanding SaskPower's argument to be an interjurisdictional immunity argument, as the Saskatchewan Court of Appeal understood that. I am now seeing that this court is viewing it as differently, that you think that the act is going to have such a big impact, it will take away too much power. So when you...
Well, this is your friend's argument. Your friend's argument is that this would take away too much power, not only on this issue, but on any issue where the national standards were attached. We've not reached any conclusion. We're just trying to understand how you would answer your friend's submissions that this constitutes a very significant, I can't recall every word that was used, but the word very significant intrusion into provincial powers, an unprecedented intrusion, the backstopism theory advanced by the council from Saskatchewan, that there's never been, in response to a question from the court, any other instance in which the federal government has ever used that. So those are all the arguments that go to the question of what's the scale of impact on provincial jurisdiction. So your friends have argued it's very substantial on many grounds, including interference on Section 92A, and indeed unprecedented in the use of a backstop provision of this kind. So in response to that, we just wanted to know what your submissions were to answer that.
I have three responses. First of all, I think there's a little bit of hyperbole involved in those submissions. But on a legal perspective...
You think there's hyperbole involved in their submissions to that effect? Okay.
Yes. So that's the first. On the second point, backstopism. I cannot point to another piece of legislation that has taken the backstop approach. What I can point to is that there is many regulations under the Canadian Environmental Protection Act that allow for stand-down agreements. So, for example, the coal-fired electricity generation regulations, the federal regulations that require the phase-out of coal-fired electricity generation by 2030. You'll see in Mr. Savage's evidence some discussion of the province's efforts to work towards phasing out coal-fired electricity generation. I don't know where we're at as to whether or not Canada and Alberta have now entered into a stand-down agreement where Canada will stand down the federal regulations to give way to the Alberta provincial regulations. I believe at the time of the evidence it was still under discussion. But in any event, there are many examples in many different pieces of legislation of those, especially environmental legislation, of that stand-down ability. That legislation federally applies unless the provinces come forward and say, we have a system that is sufficiently stringent that it meets what you say, what you are applying to us, and therefore we ask that you stand down your federal legislation so our provincial regulations can operate. The backstop approach of this legislation works from the opposite, in the opposite direction. It only applies following a stringency assessment. So this act could have taken that opposite approach. It could have taken that precedented approach. So it could have said, okay, well, the federal system is going to apply in every province. Oh, but if you tell us you have a sufficiently stringent pricing system of your own, then we'll stand it down.
It is true, though, that when you're referring to the stringency assessment, you're referring to an assessment made by the Governor and Council, not the Parliament of Canada. The Governor and Council decides whether he or she is satisfied that the effort of the province is good enough. Is, quote, in the very rule, appropriate.
It's sufficiently stringent, with stringency being the primary factor.
Right. So why is backstopism then not what they say, which is that now we're at the whim or the opinion of the Governor and Council?
The stand-down agreements are also done at the administrative level.
That's for agreements, and we're talking about now a dispute. We're talking about a constitutional debate. So forget about what agreements do. A constitutional debate. The province is asking not to be subjected to a test based on what they call backstopism. So you're saying, well, that's not, but I think I gather what you're saying. Really, is that's not very harmful to the provinces because after all, they can just go along and then there won't be any problem.
What I'm saying is that the backstop approach is because they said it's unprecedented. What I'm saying is that the backstop approach is less intrusive into the provincial powers than...
And a directly unconstitutional attack on affront on the legislation. Is that what you're saying?
No. Than the precedented stand-down approach that has been taken in many precedents, in many examples.
In environmental laws.
In environmental law context.
Right, where they use the criminal law power. Not where they specifically have jurisdiction. Not a residual jurisdiction, where they have a constitutional jurisdiction.
So then I think you have my point there.
Yeah.
I then want the other point is with respect to particularly 92A, and there's been a lot of argument about what it means and what it doesn't mean. And in particular, The reason why 92A was added, and this was analyzed in Ontario Hydro, and it's at tab 41 of Canada's condensed book at paragraph 83. And the reason it was added was because there was real concern that there was a risk that any of the electricity generation or the natural resources, the oil and gas production that was connected to a pipeline would be found to be integral to the interprovincial system and therefore be taken out of the province. So that's explained at paragraph 83.
That may be explained at paragraph 83, but if you look at the whole history of this, that is not the rationale for section 92A, and indeed the attempt to get the provinces exempted from the federal declaratory power failed. So that might have been one of the reasons for starting down the 92A road, but it certainly wasn't the end result. The provinces of Saskatchewan and Alberta, who were the prime proponents, with the rest of the provinces letting Alberta and Saskatchewan take the lead on this, were unsuccessful in having the control over natural resource, the federal ability to use the declaratory power override the province's exclusive right to manage their resources. And by the way, while I'm thinking of it, because I meant to ask this earlier, can you tell me if you know, and this is just as an aside, but I'd be interested in the answer, when was the last time the federal government ever used the declaratory power to declare something to be of benefit to Canada as a whole? Was that something, I was trying to think whether that's been recently, in recent memory. Okay, all
I
right.
think it might be discussed in the Central Western Railway case, because that was an issue that we had.
It was a long time ago in any event.
It might be the bridge from Prince Edward Island to New Brunswick.
Maybe. I honestly do not know.
But the reason I say that is 92A, I understand that perhaps, I'm not sure to what extent this obviously has been thoroughly canvassed, but there is a lot of literature on this, and it is quite extensive, and it's very clear that Alberta and Saskatchewan were negotiating this amendment in response to decisions of the Supreme Court of Canada relating to the potash industry in particular, and concerns that they had over the federal intrusion into natural resources in Canada.
I commend you to the paragraphs in our factum. We did a very extensive legislative review. There are a lot of footnotes there, and those are all, that material will be before you. One thing that is clear from that legislative process is that it also wasn't viewed as affecting Parliament's power over Parliament's peace order and good government power. And that exchange, I've pulled out one of the exchanges that shows that, and that's at tab 48 of Parliament.
I found it very interesting to read the history of the negotiation of that was done by two people who were instrumental in the negotiation, which was Meekinson from Alberta and Roy Romano from Saskatchewan. So they wrote an extensive article detailing all of the various meetings and the history over a period of two to 3 years, and the various conferences at First Ministers' conferences, and what had been decided and what happened, and how the federal government, how at one point, according to them, had agreed to the override, as it were, the declaratory power, and then eventually decided that that was not the route they were going to go, and that was therefore never incorporated in the legislation.
So we have provided references to the original sources, the debates, the discussions, the conferences, in our Book of Authorities and in our footnotes. So that's there for this court to read. But there was certainly the exchange that is at tab 48 of our Book of Authorities. Mr. Justice Strayer, then, who was the law officer for the Crown, was being asked questions by Senator Roblin from Manitoba about the impact of adding 92A on, particularly on he was concerned it was an interprovincial cooperators case that he was raising up, and he was concerned that about the availability of Ontario to manage a power plant and pollute the river all it wanted to, and they wanted specifically to he wanted an amendment so that it wouldn't allow Ontario to do that when that was flowing downstream into Manitoba. And Mr. Strayer, twice in discussing those potential, and one other potential amendment, made clear that the federal jurisdiction remains with respect to navigation and shipping, with respect to fisheries, peace order, and good government. That was specifically raising the question of interprovincial cooperators and whether the amendment to 92A would impact Parliament's POG power. And in the debates, it was clear that it was not going to impact Parliament's POG power.
Well, it certainly doesn't impact Parliament's emergency POG power, and it certainly doesn't impact the gap portion of Parliament's POG power. But when you look at the issue of national concern and how this all fits, I am sure that we're Peter Lougheed here today and talking about this. It's in reading about it, this was a very important negotiation over 3 years for the addition of this provision to the Constitution. And it was described at one point by then Prime Minister Trudeau, as I recall, as a, quote, concession. And it was written, if you look at the one article, on the basis that they...
We said that it kept Quebec from separating. That article, as I recall.
I don't recall that, but I do recall that it was described as a concession.
Giving the provinces some export powers as well.
Right.
Well, it was also regarded as a confirmation, but a very important confirmation of the powers that the provinces thought they had, which, by the way, raises another issue that I've never asked you about, and that is, how do you say that we should, if at all, factor in the province's ownership of the resources into this analysis? We've been talking a lot about the province's regulatory authority, its own regulatory authority, its control over property and civil rights, which it can do vis-a-vis other people, but these resources are owned by the province.
It doesn't affect the province's ownership of the resources at all. It prices the emissions.
Mm-hmm. And does it affect, of course, you've answered this earlier, my point was about the eventual control over the development of the resources. Does it affect that at all? Does it affect the ownership interest to the extent that it controls in any way the ultimate development of the resources?
We say that not on the evidence before this court.
And the evidence before this court is based on what the current charges are, not what they could be in the future. And you've agreed that the discretion is there for the federal government to raise those charges as it sees fit.
There is absolutely discussion to raise those charges. That doesn't mean that there's any intention to raise those charges. What we know now is that it is to go to $50 a ton by 2022, and that there are going to be a federal, provincial, territorial review before anything further.
Well, can I also ask, because the intention is to reduce the greenhouse gas emissions, and part of it is to change behavior and to curtail demand, what would be the effect on the development of fossil fuels if demand were substantially curtailed? In other words, is there not some link between reducing demands and ultimate development of resources?
Well, ultimately, demand for greenhouse gases is going to have to go down. Emissions are going to have to go down, or the impacts of climate change are going to be an existential crisis. We are in a time of transition. The Pan-Canadian framework is about transitioning to...
I'm just getting at the point that your friend's argument on Section 92A includes, as I understand it, the submission that in reducing demand, you ultimately reduce the value of development, if not development itself of the resource. Indeed, that would arguably be one of the direct intentions. The intention is to reduce demand. That's the whole purpose of the legislation.
But not.
It's ultimately to actually get rid of all this, because cleaner energy is one of the preamble statements too. Cleaner energy. In other words, that means get rid of all this stuff totally someday.
Ultimately, the classification of the act, it will be up to this court, of course. We say that it meets the...
In fact, some of the people on the side of the the earth, you might say. And I'm not trivializing. These people are here, they're serious, and they make very good points. They would probably be just as happy if the oil and gas industry disappeared completely. Now, you're saying the federal government doesn't intend that.
But then the legislation is not like, the legislation doesn't do that. It reduces demand. But it reduces greenhouse gas emissions. But it's not directed at that power. Anyway, I think I'm not sure there's much more debate on this point. I think you have our submissions. So just before I turn matters over to my colleague for a few minutes, if the court will indulge, if the court wants to hear on the regulatory charge position.
Well, just one last thing, just since you're already sitting down, I want to make sure, again, to be fair to you, that I got down something you said before. And that is your position, Canada's position, not your personal position, obviously. Canada's position is that in order to determine that the scale of impact is such on that part of the test for national concern is enough, the degree of impact, the scale of impact is enough. It does not have to attack the core of the provincial power.
That is the question. It doesn't matter.
Right. So, okay. Just so I just want to make sure I understand that.
No, that was a disconnect in understanding from how the Saskatchewan Court of Appeal understood and cared SaskPower's arguments, and from how this court is.
Right, I got it.
Did you want to sum up then? I know you've answered so many questions and been here a long time, and you might be exhausted from all this, but if you wanted to take a couple of minutes to just sum up.
I don't know. I mean, we say the act in pith and substance is related to establishing minimum national standards integral to reducing nationwide greenhouse gas emissions, and that this meets the Crown-Zellerbach test. And for this reason, it is constitutional under Parliament's peace order and good power. I think just before I turn it over to my colleagues, I have two comments on the submissions of the interveners to come, which is that the reference question before this is very broad. It asks whether the act is constitutional in whole or in part. It's a proper role for interveners to bring unlimited powers to this court for this court's consideration. Canada may not have a monopoly on the best thinking of what indeed in Hydro-Quebec, it was an independent law power. Ultimately, Canada also made some arguments on it, but not at the courts below. So, and secondly, Canada agrees with Indigenous interveners that the answers to the questions posed to this court on this appeal must be respectful of the entire constitutional framework, including Section 35.
Thank you very much, and we're really grateful to you for your submissions and for all your work in putting materials together as well. This is very helpful to us. Thank you.
Mindful of the time, and I'm in your hands.
I'll hear you.
From your advance sheet, you indicated you're basically talking Section 53 and all that?
Yes, I was going to address both the proper characterization of the charge, and the fuel charge under Part 1 of the Act. That's the analysis under West Bank. And secondly, the Section 53 argument. So I would just be responding to the arguments raised by the Attorney General of Saskatchewan, Sask Energy, and Sask Power, and the Canadian Taxpayers Federation.
Well, the West Bank analysis is basically, is this a tax or is this a regulatory levy?
I'm sorry?
So the West Bank analysis is basically going to address whether this is a tax or a regulatory levy?
Exactly.
Okay.
Exactly. And Canada says that under the existing jurisprudence, both the fuel charge and the excess emissions charge are properly characterized as regulatory charges.
I was going to ask if you could put that mic down so that you're speaking more directly into it. I'm only concerned because I'm not quite sure how the podcast works, but I do know that that there was variation yesterday with people turning away from the mic.
And you're laboring obviously under a ailment too.
Yes. I may do as my friend did and need to sit down, but hopefully I can make it through. We know from the case law, and in particular the 620 Connaught, that to determine if a government levy is a tax or a regulatory charge, one must consider first whether there is a valid regulatory charge, and secondly whether the charges are connected to the scheme. So at step one of the test, the West Bank test, the court set out 4 factors. I won't go through, I'll go through the 4 factors. I won't roadmap it for you. I'll just start. My friend Mr. Halser explained that not all 4 criteria need to be satisfied there. It's not exhaustive.
But just to sort of cut through to the core point,
Yes.
I think your position would be, look, it's not a tax because this is not being used for a public purpose. It's the amount that's raised is on the overarching test.
That's right. And in particular, and we know from 620 Connaught at paragraph 16 and 17, this is in our condensed book, we don't need to turn it up, that the primary factor and the key factor the courts look at, which is the second step of the test, is to look at the dominant or most important characteristic of the levy to assess whether the charge is connected. And in this case, it's clear, and my colleague has taken you through this, and it's clear from the preamble and the scheme of the act as a whole, the purpose, the dominant purpose of the fuel charge in particular is to modify behavior. The charges are intended to create a financial incentive for businesses and individuals to change their behavior in ways that will reduce national greenhouse gas emissions and encourage innovation in low emissions technology. And in particular, the Act does not have a revenue generation purpose. And I can point you to the sections of the Act that make that clear. So at tab 1 of our condensed book, if you would turn to section 165 sub 2.
165 and 188.
Yes, it's one.
2 respectively.
That's right. And 165.1 defines, 165 sub 1 defines the net amount, which is all of the charges that are collected. And that total amount, the distribution of that total amount in section 165 sub 2, the Act directs that the minister, and this is the Minister of National Revenue in Part 1, must distribute the net amount for a period fixed by the minister if positive in respect of the province or area. The minister may distribute that amount either to the province, to persons that are prescribed persons or persons of a prescribed class or persons meeting prescribed conditions, or to a combination of A and B. And we know that that is what has happened in the provinces to which the fuel charge has applied. And I'll just give you the references in Mr. Moffat's affidavit at paragraph 141 and 142. He discusses the announcement made by the minister to distribute 90% of the net amount in the backstop provinces through the climate action incentive payments. And Mr. Ruel's affidavit, which is also excerpted in the condensed book at tab 30, sets out the amounts that have been returned to the provinces. The other 10%, of course, are going to, within the province, to municipalities, hospitals, and so forth.
And so it's essentially a revenue neutral scheme.
Yes.
And when it's returned to individuals under the climate incentive plan,
Yes.
Because it's got a regressive nature to this charge, there's some allocation made for individuals at a lower level of income, I believe, is that
There's
so?
an additional 10%, as my friend.
Additional 10%.
Yes.
And I also note that...
And that's based on whether they're in a rural community.
And I also note that the payments don't just go to adults, that there are payments as well to children as well.
It's based on family size.
I wasn't quite sure how that related to
Right.
the use of, to carbon emissions, but nevertheless, I take that to be just part of what is perceived as being something that from a policy point of view worked well for families.
Yes, and just to be clear, it's not based on income. It's not an income test. The specifics are set out in 122.8 of the Income Tax Act, which is in the record. It's in Budget Implementation Act number 2. It's in our authorities at, I believe it's tab 22. So there is a specific provision in the Income Tax Act that sets out prescribes the
There's a
persons.
disproportionate payment to people who are in rural areas, right?
Yes.
Yeah. Yeah. What was the rationale for doing it based on number of children? How is that related to, what's the theory behind this?
I believe the Mr. Rule, I'm not sure if Mr. Rule's affidavit addressed that in particular. But the climate action incentive payment at paragraph 2, so this is at tab 30 of our condensed book, and it explains that the payment is a refundable credit consisting of a basic amount plus a 10% supplement. And the amounts, I'll have to find the reference for you. There's a different amount for an individual, a couple, and then a family.
But the main point is just that it is revenue neutral.
Yes, revenue neutral, and the Act, it uses the concept of revenue recycling. So even though, as my friend explained, even though the money is returned, ultimately most of the money is returned to those individuals within the province, the price signal is still effective. So the fact that there is an increasing price on carbon will have effects on demand.
I did read some materials in terms of an affidavit filed, I think very late, that went through the 3 different options, the carbon pricing as opposed to, for example, different ways of spurring innovation and so on, and the carbon pricing was considered to be the most effective way to get the most effective results for the least cost to the public.
Right, so economic efficiency, it's well understood as the most efficient means to reduce demand. So I skipped over briefly that there is a complete, complex, and detailed code of regulation in our factum. We've set out and pointed you to the provisions of the Act that explain the scheme and why it meets that criteria. I'll just add that one of the flaws in my friend's argument, I think, is that they're parsing out Part 1, and you have to view the Act as a whole. The 2 parts of the Act are complementary, and each part performs a distinct role. And the overall objective of the Act is to ensure that pricing has broad application across Canada through targeted schemes that apply to both industry and producers, and that can address emissions intensity in trade exposed sectors differently and take into account the differences to ensure that competitiveness is considered and addressed, as well as applying to producers, distributors on the fuel charge side. So it's applying a carbon price across all sectors of the economy.
I do understand the concept of changing behavior when it comes to driving a car, because I can see that people have a choice. You could get to an electric car or some other, carpooling or whatever, or taking public transit if it is close to where you live. I'm less aware of how people can change behavior when it comes to heating their homes, when there's only one way to heat your home. So I'm not quite sure about this theory about how that would change behavior on heating homes.
Well, just as my friend referred to, when you consider whether to buy your next vehicle, you might choose a vehicle that is better on gas. You might, when it's time to replace your furnace, purchase a more fuel efficient furnace. Or, there are incentives in that way that, and again, it's spurring innovation across the economy so that their businesses will produce products that are more energy efficient, and that will have a trickle-down effect.
Are those incentives in the Act itself?
The incentive is the effect of pricing carbon. So by pricing carbon, there will be, we need to encourage businesses to invest and to innovate and to develop technologies that will be more energy efficient.
As you heard, SaskPower thinks that it's not quite so easy in Saskatchewan.
Well,
And not quite so immediate either.
right, and there are complex problems here, and we are going to have to address those complexities. And Saskatchewan has developed a scheme that was acceptable. There is partial application, but Saskatchewan has developed a scheme that.
But at the end of the day, for consumer, and let's be clear, I mean, consumer, under Part 1, it's the consumer who's paying. That's the end result, because these charges are being passed on to consumers. So for consumers, for heating a home, for example, you may already have an energy efficient furnace. How would your behavior change? Unless it's just to do what your mom said, which is turn down the heat and turn off the lights when you go out of a room. So beyond that, turn down the heat, what is there that individuals can do about changing their behavior in terms of heating their home?
Well, not all individuals will be able to lower all of their energy, use in the same ways. But one individual might be able to carpool, but not, maybe their furnace is as efficient as it is, but they may find other ways. And remember that on the individual level, they're getting the climate action incentive payment back, and in many cases, the climate incentive action payment will be more than they expend.
Well, some are getting less, though, too.
In order to do that, to make it neutral. I mean, paragraph 24, of course, you didn't have to go through it. Westbank, though, talks about a regulatory scheme. It seems to me that when you're arguing that this is a complex regulatory scheme, it's a complex pricing scheme. There's not much regulation involved in this, is there? You set a baseline price and you enforce it. Well, how has it become a complex regulatory scheme?
It is a complex regulatory scheme. It does a variety of things. It has very detailed provisions setting out who the charges apply to, what fuels they apply to, how the fuels, the formulas set out. It sets out registration requirements for those that are required to pay the charges. It also sets out certain exemptions for those that are.
But you heard my point, though. Right? It's a complex pricing scheme. It doesn't regulate anything. In fact, I thought Canada was trying to say, well, we're not purporting to regulate how you do your business. We're not purporting to tell Saskatchewan, Alberta, and all the rest of them how to run the industries which create these problems. We're not doing that. We're just telling you, here's the cutoff line on cost. Now, it's true that there's a whole variety of different, as you point out, and a further regulatory power for the governing council. But I'm suggesting to you that it's not necessarily a regulatory scheme, it's a pricing scheme. And so I guess obviously you don't agree. It does, under Westbank, it does seek to affect the behavior of individuals. I got that. The actual or properly estimated costs of the regulation, doesn't support this, does it? I mean, if that's a factor that doesn't say this is a scheme. Right, exactly. That's like Connaught knowledge. You're talking about the administration of something like, I don't know, elevators or something. There's a cost to that sort of thing. I guess that's not even the right one. Maybe real estate or something. So that's not it. Doesn't help. A relationship between the regulation and the person being regulated, where the person being regulated either causes the need for the regulation or benefits from it. Now, it's kind of a stretch to say they benefit from it because the air is cleaner, and it seems to me, and it causes to say the motorist causes the need for the regulation is a rather carpet bombing approach to who's responsible for greenhouse gas emissions. So are you saying that part 4, that factor 4 in paragraph 24 supports this as not a tax?
Absolutely.
Okay.
Those who consume and create emissions, greenhouse gas emissions, they are causing the need for this. We, collectively, citizens of the world, have caused this issue, and Canada is up there as one of the highest emitters.
So in that event, they're not regulating those people.
We are causing the need for this regulation.
Right, but that's the point. They're not regulating those people.
We will also benefit because if emissions are reduced and we can hold the increasing average temperature to 1.5, we will avoid a lot of catastrophic events that will cause other problems. So there is going to be a transition period. It's going to be difficult, but we have to look at what we're trying to avoid here.
Right.
Because the flooding, the wildfires,
Okay.
the greater hurricanes that are going to hit the Maritimes, there's a lot coming our way if we don't act. And we have to bear that in mind as we're balancing the need.
I asked yesterday whether there had been any consideration given to the fact that when you're living in a more inclement climate, it costs you more money. And I guess your answer to that would be, yes, it's true, it does, but you'll get more back as you'll get back whatever it is that the province is contributing.
That's right. So the whole province is in the Ruel, Mr. Ruel's affidavit. It does set out the amount. Sorry, it does set out the amounts that have been returned. And
We're at tab.
that is tab 30 of our condensed book. And for the taxation year 2018, and this was as of the calculations done in June of this year, just under $224 million were returned to the residents of Saskatchewan for that year, to 530,000 individuals within the province. And so, with respect to the valid regulatory scheme, we do say that this is a regulatory scheme. And to your point, Justice Watson, a pricing scheme, I would submit, is a regulatory scheme. And the two parts, the OBPS and the fuel charge system, are integrated and complementary and form a whole regime of pricing. So with respect to the second step of West Bank, I would just direct the court. There was an issue raised and that was dealt with in the other two courts as well, as to whether the connection is required and how the connection can be met when we're dealing with a behavior modification charge. And I just want to take the court to the West Bank decision, which is at tab 44, or sorry, tab 50 of our condensed book, paragraph 44, because it was suggested that there needs to be some connection between the charges, the charge and the cost of the scheme. And the court very clearly contemplated in West Bank that the connection can be demonstrated. And I'll just read from the decision in paragraph 44 towards the bottom. In order for a charge to be connected or adhesive to this regulatory scheme, the court must establish a relationship between the charge and the scheme itself. This will exist when the revenues are tied to the cost of the regulatory scheme or where the charges themselves have a regulatory purpose, such as the regulation of certain behavior. And we say that is clearly shown here, and that is sufficient to meet the connection at the second step of the West Bank analysis. So in our submission, the nexus requirement is met, and the regulatory charge is clearly not a tax. We have pointed the court to the Johnny Walker case as another example. That was the customs duty case where it was recognized as falling under the trade and commerce power, and that continues to be the case to this day. There was significant amount of evidence to support the regulatory purpose of the charge. And we would just refer you again to Mr. Moffat's affidavit, Mr. Rivers' affidavit, Mr. Goodlett's affidavit. And this is all set out in our factum, paragraphs 24 to 5 and 30 to 32. So the final point I would make with respect to the characterization is that logically, with respect to a behavior modifying charge, requiring a connection between the charges and the costs would be incompatible with the function and design of a behavior modifying charge, because in order to be effective, its rate has to be set at the level that will produce the desired behavioral change, irrespective of the cost of the scheme or other factors. So I will just turn very quickly to the last argument, which is in relation to Section 53. And I just want to be clear that Canada has never taken the position that these are taxes. In that Part 1 imposes a tax. We say quite clearly in our factum, and we have each court maintained it is a regulatory charge. So this argument is only if this court were to decide that the fuel charge in Part 1 of the Act is our response to my friends with the CTF and Saskatchewan's argument is that there is no constitutional principle of uniformity. Second, that Section 53 can be met even if the word tax is not used. And third, that the delegation within the Act is clear and unambiguous. And I'll just say briefly with respect to the principle of uniformity, there is no constitutional requirement of uniformity in the operation of federal legislation. We've provided you several cases to that point, and my friends have not offered similar authority. They have relied on, and the Court of Appeal minority relied on the decision, 1926 decision, Ministry of Finance and Smith. And I would ask the court to have a close reading of that case. That case was a statutory interpretation case, and there is a line in the decision that deals with whether or not the ill-gotten gains from the sale of alcohol fell within the definition of income in the Income War Tax Act. And the court did conclude that it did. But the principle there that my friends rely on, it was supportive of the interpretation. The court was not expounding a proposition that there is a requirement of uniformity in federal legislation.
I take it that you would agree if we found that it's not a tax, we don't have to get into this issue of whether there's a uniformity requirement for law in Canada, because that's a very interesting issue. I mean, part of the concept has been that there should be an ability to make a distinction based on local circumstances. For example, our criminal law is different in terms of how what happens with respect to the offense of murder and the rights you have and so on, re-jury, no jury, which is very different from other parts of Canada. But the broader issue of, is there a concept of substantive equality which should be incorporated given the existing jurisprudence on the Charter generally? Is there some room for changing the way we deal with that in Canada so that you have a law which purports to have a neutral application, but which actually has a disproportionately negative impact on one part of the country, that's a very interesting issue, and that would take a lot of further arguments and submissions, and we have not actually gotten into that issue. So I guess I just wanted to be clear that if in fact we found there was no tax, we need not deal with that issue.
Absolutely, that's correct. And I would just add that this act, by its nature, does ensure that the provinces are treated equally in a substantive sense. And that's part of its goal, is that across Canada there will be pricing. And there may be some differences depending on how each province sets up its own system.
And so
Cap and trade is different from tier, but there is an attempt to have some form of pricing across Canada.
And on the Part 1 provision, your point would be, look, in large part, that money is coming back to the province, and while the federal government has some discretion as to how to return it, the fact is it is coming back to generally to the group that paid the money, not specifically to the individuals, but generally to the population. So even though the federal government sets the terms and conditions under which it can be done, that doesn't in any way negate the fact that it is being returned to the specific jurisdiction. Okay.
Now, I think with respect to the argument that because Parliament didn't use the word tax, I think that there really are only two possibilities here. And if you conclude that it's not a regulatory charge, then it is a tax, regardless of what it's called. There are many cases where, such as Uriga State or West Bank, that charges were called fees. They were found to be taxes. The opposite is true. There's no magic words. And so we say that excuse me, that the fact that Parliament didn't use the word tax, it does not cause a problem for Section 53 of the Constitution Act. And I'll refer you to AG Quebec and Algonquin. This is in the authorities. The Quebec Court of Appeal made this point as well at paragraph 47. Finally, the delegation point, it will be my last point. We say the delegation within the Act is clear and unambiguous. The essential features of the Act are not delegated, and the delegation to amend Part 1, Schedule 1 is clear. In Uric, the court allowed that the details and mechanism of a tax may be delegated, and the references are at paragraphs 30, 40, and 55, so that's including the dissenting. All the judges agreed on that point. And the Ontario English Catholic Teachers Association, paragraphs 74 and 75 in particular. And my friend's argument that the listing of the provinces, that there's a problem with the delegation there, is very similar to what occurred in the National Steel Limited case. And I'll just give you the references there at paragraph 85 to 87. In that case, aspects of Ontario's electricity were challenged, specifically the imposition of a global adjustment that incorporated into electricity rates. For certain businesses, the cost of procurement contracts with companies that were providing electricity produced by renewable energy sources. And the court held there that it was a regulatory charge, same issues, and that it was imposed by 25.33 of the Electricity Act. And Section 25.33 provided for adjustments to be in accordance with the regulations. Then the regulations set out the formula. And so there is a great deal of leeway for delegation within legislation of this nature. And we have set out, I don't think I need to take the court through it, we've set out that the structure of the tax, of the charge, the rates, the time period, and the principles for the imposition of the charge are all laid out in the Act. And I would commend to you the reasons, the majority of the Saskatchewan Court of Appeal on this at paragraphs 103 to 108. So subject to any questions the court may have, I
think it's a good time.
Thank you. You've dealt with that in a very succinct way, and thank you so much for that. Are there any questions that the panel has? Then I think that we had hoped to hear from some of the interveners today, but I think that because of the lateness of the hour, we will now leave that till tomorrow. So we'll see you all tomorrow morning at 10 a.m. Thank you.
Thank you.